terhadap persoalan-persoalan, baik persoalan hukum maupun persoalan-persoalan sosial lainnya. Maka pada kesempatan yang baik ini, izinkan kami atas nama Rektor Universitas Muhammadiyah Bengkulu mengucapkan selamat berkonferensi. Mudah-mudahan bisa memberikan kontribusi yang positif bagi pengembangan ilmu pengetahuan maupun kontribusi yang positif bagi pengembangan masyarakat lokal, nasional maupun masyarakat internasional. Terima kasih. Nasrun minallah wa batun qarib. Wa basiril mu'minin. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much, rectors of Universitas Muhammadiyah Bengkulu, that already opened the ICONLAPP, second ICONLAPP of Universitas Muhammadiyah Bengkulu. So ladies and gentlemen, now we have successfully concluded the opening ceremony. I am Master of Ceremony, would like to say thank you very much for all the audience that already become amazing participants for the sessions. So now we have arrived to the pinnacles of this event, the second International Conference on Law, Policy, and Politic. Without any further ado, let us welcome our moderator for today, Exa Reva Amalia, Bachelor of International Relations. Tom is yours.
Thank you very much, Ms. Nanda, for your amazing opening session. Assalamualaikum warahmatullahi wabarakatuh. Good morning, distinguished participants and speakers. Welcome to the second International Conference on Law, Policy, and Politics, organized by the Faculty of Law and the Faculty of Social and Political Sciences, Universitas Muhammadiyah Bengkulu. My name is Exarefa Amalia, and I will be honored to be the moderator of this session. This session features two keynote speakers that bring together the perspective from practice, law, and political studies on the contemporary issues on law, policy, and politics. Each speaker will be given up to 45 minutes for their presentation, and at the end of these sessions, we will have 15 minutes for the discussion and the answer and question segment. And I kindly ask for all the speakers to observe the allocated time to ensure a smooth and productive session. Thank you. And now we will starting the conference. Ladies and gentlemen, our first speaker is Mr. Jordan Gunawan, MBA, MHA, PhD. He is an associate professor in Public International Law at Universitas Muhammadiyah Yogyakarta. Mr. Gunawan specialized in Public International Law, International Dispute Settlement, International Organization, and International Environmental Law, and has extensive experience both as an academic and in international accreditation and collaborative activities, including serving as a country expert for FIBAA accreditation team in Germany. Everyone, please welcome Dr. Jordan Gunawan.
Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, all the participants of this conference, ICONLAPP, held by Universitas Muhammadiyah Bengkulu. Thank you very much for giving me an opportunity to share my knowledge on the green justice or green colonialism, environmental law, and power in the global south. So I'm very glad to be part of this conference, which as I know that Universitas Muhammadiyah Bengkulu is one of the most promising university in Sumatra and in Indonesia. So let me just introduce myself. My name is Jordan Gunawan. I'm an associate professor in the public international law field from Universitas Muhammadiyah Yogyakarta. So I start my presentations on the introductions of uh, my topics, that we already knows that environmental protections has become one of the most pressing global concern in contemporary international relations, also international law. As a result of escalating climate change, widespread deforestations, pollutions, and severe environmental degradations that threaten the ecosystem, human livelihood, and also global stability. The climate change has intensified extreme weather events, rising sea levels, food insecurity, and also biodiversity loss, while deforestations and environmental exploitation continue to undermine ecological balance and also the survival of indigenous and local communities. Ladies and gentlemen, because these environmental problems transcend national borders and affect the entire planet, they actually have prompted the development of numerous international environmental laws, treaties, and agreements intended to coordinate collective actions, establish common standards, and also promote sustainability development worldwide. However, the creation and governance of most of these international environmental frameworks are largely dominated by developed countries and international institutions based on the global north, which possess greater economic powers and technological capacity, scientific expertise, and political influence. And as a result, the environmental norms and standards embedded in the global agreements often reflects the priorities, interests, and also historical experiences of developed nations rather than the diverse realities of developing countries. The situations raises significant concern about fairness and also equity in global environmental governance, particularly for countries in the global south. Many developing countries are required to comply with strict environmental standards as condition for receiving financial assistance, uh, foreign investment or access to international markets, despite their limited financial resources, weaker institutional capacity, and ongoing development needs. This requirement can place disappropriate net burden on the global south, as compliance often demands costly technologies, regulatory reforms, and restrictions on the use of natural resources that are essential for economic growth and poverty reductions. Furthermore, this dynamic overlook the historical responsibility of developed countries, of course, uh, whose industrialization and economic expansion were achieved through intensive resource extraction and high levels of environmental pollutions over many decades. And in contrast, we can see that developing countries which have contributed far less to global environmental degradations are now expected to bear significant responsibilities in addressing environmental problems they did not primarily create. Consequently, the enforcement of global north design environmental standard in the global south can reinforce existing power imbalance, limit policy autonomy, and reproduce structural inequalities within the international system, uh, raising critical questions about justice, sovereignty, and the need for more inclusive, equitable, and context-sensitive approaches to the global environmental governance. Uh, then I will show you for the next slides on the green justice. What does it mean with the green justice as a key concept of my presentations? This green justice is a normative and ethical approach to environmental governance that emphasizes fairness, equality, and social justice and the design and implementation of the environmental policies. Rather than focusing solely on environmental protection outcomes, green justice highlights who bears the cost of environmental regulation and who receive uh, the benefit of it. It seeks to ensure that environmental protection measures do not disproportionately burden vulnerable or marginalized group, particularly those in developing countries that often lack financial resources, political influence, and also institutional capacity. From a green justice perspective, of course, ladies and gentlemen, environmental policies should not reproduce existing social and economic inequalities, but instead contribute to reducing them by taking into account historical responsibility, um, different levels of development, and also unequal access to power and also resources. I'm sure that a central principles of green justice is the equitable distributions of environmental benefits and also burden. This principle recognizes that environmental protections involve both costs and also advantages, and also justice requires that this be shared fairly among all actors. Environmental burdens may include restrictions on land use, limits on the resource extractions, increased production costs, or displacement caused by conservation project. Um, Ladies and gentlemen, as we can see also, environmental benefit, on the other hand, include access to clean air and water, healthy ecosystem, climate resilience, and also um, financial assistance. Um, I think last but not least, about technological support. And in practice, however, these burdens often fall disproportionately in poorer communities and developing countries, while the benefits are captured by powerful states, um, what is the international corporations or other elites. uh, and then this is the challenge of the green justice, which actually imbalanced by arguing that those who have historically contributed most to environmental degradation and those with greater economic capacity should bear a larger share of the responsibility for environmental protection and provide meaningful support to those facing the greatest constraint. Ladies and gentlemen, we can see that equally important to green justice is the recognitions of local communities and indigenous people as central actors and right holders in environmental governance. Indigenous people and also local communities often depend directly on natural resources for their daily life, livelihoods, and also cultural identity and social cohesion. And they possess valuable traditional knowledge that has contributed to sustainable environmental management over generations. And then also we can see that green justice reject approaches that treat these communities merely as beneficiaries or obstacles to conservations, and instead emphasize their right to land, self-determinations, including participation and also consent. So the recognitions of indigenous land rights, respect for customary law, and inclusion of local voices in decision-making processes, I think, are essential not only for justice, but also for legitimacy and effectiveness of the environmental governance. Without such recognition, environmental policies risk causing displacement, cultural loss, and we know this kind of things, like also social conflicts, undermining both human rights and also environmental goals. So this concept positions green justice as a framework that connect environmental protections with social equity, human rights, and political inclusions, of course. And it calls for environmental governance system that are inclusive, participatory, and sensitive to local contexts, while also addressing global inequalities between developed and also developing countries. Um, by promoting fair burden sharing, recognizing historical responsibility, and also respecting the right and knowledge of indigenous and local communities, green justice offers a more ethical and sustainable foundation for addressing global environmental challenges in increasingly unequal world. And then we can see the next slides talking about the green colonialism, which refers to a contemporary form of domination in which environmental policies and sustainability agendas are used by powerful countries, international institutions, or transnational actors to influence, regulate, or even control weaker states, particularly in the global south. Under the guise of the environmental protection and climate responsibility, of course, the policies, ladies and gentlemen, often function as instrument of political and economic power rather than purely ecological solutions. So developed countries and global financial institutions frequently attach the environmental conditions to development aid, climate change, foreign investment, or access to international markets, effectively compelling developing countries to adopt regulatory framework designed elsewhere. While these measures are presented as necessary for global environmental protections, they can significantly constrain the policy autonomy of weaker states and reinforce dependency on external funding and also approval. Ladies and gentlemen, and also beloved students, a defining characteristic of a green colonialism is the impositions of the environmental restrictions without sufficient conservations of the local realities. Many environmental standards are applied uniformly across diverse contexts, ignoring vast differences in economic capacity, social structure, cultural practices, and also development priorities. In developing countries like Indonesia and most of Southeast Asia's countries, such restrictions may limit access to land, forests, or natural resources that local populations depend on for their livelihoods, for security, and also cultural survival. Conservation projects, carbon offset schemes, and also renewable energy development might lead to land dispositions, displacement, or loss of traditional practices when implemented without meaningful consultation or consent. And the result is communities that have contributed minimal to global environmental degradations often bear the greatest cost of environmental policies, exacerbating poverty, social inequality, and also political marginalizations, as also I mentioned previously. More broadly, green colonialism reproduces colonial power relations under a new moral and environmental justifications. Although former colonial rule has ended, similar hierarchies persist when global North actors continue to define what constitute quote unquote acceptable environmental behavior and impose these definitions on the global South. Uh, Decision-making authority remains concentrated in institutions and states that historically benefited from colonial exploitations and industrializations, while developing countries are positioned as rule takers rather than an equal partners or colleagues in the side of the uh, global north. Of course, the dynamic maintains a structural inequality by framing control and intervention as environmentally necessary and ethical justified, masking underlying power asymmetries. Consequently, green colonialism highlight the need to critically examine global environmental governance and to move toward more equitable, inclusive, and also context-sensitive approaches that respect sovereignty, address historical responsibility, and prioritize justice alongside environmental sustainability. And the next slide will talk about how the environmental law in the global south has expanded rapidly over the past few decades, ladies and gentlemen, particularly in response to growing international concern over climate change, biodiversity loss, and environmental degradations. Many developing countries have swiftly adopted climate legislations, conservation framework, and also sustainability standard that mirror global norms promoted by international organizations in developed countries. While this rapid legal development is often presented as evidence of global commitment to environmental protections, uh, and it has frequently occurred without sufficient domestic debate, institutional readiness, or meaningful participation from affected communities, of course. And what is the result? We can see that environmental laws are sometimes implemented in a context where regulatory capacity is um, uh, actually limited. Enforcement mechanism also totally weak, and the social and economic consequences of such laws have not been fully assessed. This accelerated adoption of environmental legislation in the global south is largely driven by external pressures rather than purely domestic policy priorities. So, international environmental agreements, conditional development aid, climate change mechanism, and trade requirement of an incentivize to compel developing countries to align their legal framework with global environmental standards, of course, and access to loan, grants, foreign investment, international markets is frequently contingent. What is Upon demonstrating compliance with specific environmental regulation or sustainability benchmark. And the consequence is environmental lawmaking in global south can become a strategic response to international expectations rather than a process grounded in local needs, development goals, and democratic deliberations. These dynamics risk undermining national sovereignty and policy autonomy while also placing disproportionate regulatory burdens on countries that face pressing challenges uh, such as like poverty reductions, economic development, and also social inequality. Moreover, when environmental laws are adopted primarily to satisfy international requirements, uh, they may lack social legitimacy and practical effectiveness at the local level. Uniform standard designed by the global north might not align with local environmental conditions. And then customary land use system or informal economics that support millions of livelihood in the global south. And I think without adequate financial support, technological transfer, and also institutional capacity building, these laws can remain symbolic or even worse, um, produce unintended harm to vulnerable population situations. Therefore, the experience of environmental law in the global south highlight the need for more inclusive. Um, they need also to participate in this context, and also how we can see the approach, the global environmental governance that have to be balanced, environmental protection with the social justice, development needs, and also respect for the local realities. So, what about the roles of the international institutions? Here we can see the international institution play a central role in shaping global environmental governance and significantly influence how environmental policies and laws are designed and implemented, especially in countries of the global south. Among the most influential actors are the United Nations Environmental Regime, which includes international agreement, convention, and specialized bodies that set global norms and standards for environmental protections. And I do believe, ladies and gentlemen, through these treaties on climate change, biodiversity, and also sustainable development, this United Nations provides a framework for collective action, establishes expectation for state behavior. While this regime promote cooperation and raise environmental awareness, they often reflects compromises shaped by powerful states resulting in standards that may not fully account for the developmental challenges and historical responsibilities of developing countries. And consequently, of course, the global South states frequently participate as norm adopters rather than norm creators, limiting their what is the influence over the substance of the environmental rules in global. In addition to the United Nations, international financial institutions, for example, like World Bank and also International Monetary Fund, play a decisive role through the use of environmental conditionalities, and both institutions increasingly require borrower countries to comply with environmental safeguards, sustainability criteria, and climate-related reforms as condition for receiving loans, grant, and also debt relief. Although such conditionalities are justified, ladies and gentlemen, as tools to promote sustainable development, and prevent environmental harm, they can significantly constrain domestic policy choices and prioritize externally defined environmental agendas, resulting in asymmetrical power relation between lenders and recipient. And we can see also at an international non-governmental organization or NGOs here also exert substantial influence in the global environmental governance, acting as advocates, watchdog, and also implementers of environmental project. International uh, NGOs also often shape environmental discourse, policy priorities, and also funding allocations, while their contributions, valuable expertise, resources, and global visibility, for example, to environmental issues, their dominance can marginalize local voices and also knowledge system. In some cases, international NGOs act as intermediaries between donors and also local communities, inadvertently reinforcing top-down governance structures and limiting meaningful participation by those most affected by environmental policies. And we can see also another problems, for example, like carbon market mechanism represent a growing institutional influence on environmental governance in the global south, designed to reduce global greenhouse gas emission through market-based solutions. Carbon markets allow emission reductions to be achieved where costs are lowest, often in developing countries, ladies and gentlemen. While this mechanism can generate financial flows and incentivize climate-friendly projects, they also risk, of course, for commodifying nature and transferring the burdens of emission reductions to the global south. Project linked to carbon offset may restrict land use, displace communities, prioritize corporate interests over local livelihoods if not carefully regulated. Uh, Together, I think these international institutions shape environmental governance in ways that reflect both cooperation and control, highlighting the need for more equitable, inclusive, and justice-oriented approaches to global environmental regulations. And then we move to another issue on the power dynamics, which plays a decisive roles in shaping global environmental governance, which often determining whose interests are prioritized and whose voices carry the most influence the creations and enforcement of environmental rules. Rule-making process at the international level are largely dominated by developed countries, and we do understand this kind of positions that possess superior financial resources, including the advanced technological and scientific expertise and strong legal and diplomatic capacity. These advantages enable them to participate more effectively in negotiations, draft complex regulatory frameworks, and shape the language and enforcement mechanism of international environmental agreements. What about the result? So we see that global environmental norms and standards frequently reflects the priorities, values, and economic interests of the global north, uh, while alternative perspective from developing countries receive limited attentions. Uh, Ladies and gentlemen, and beloved students, as we can see that in contrast, states in the global south often face significant constraint in their ability to bargain effectively within international environmental negotiations. Limited financial resources restrict their capacity to send large or specialized delegations, commission scientific studies, or engage in prolonged diplomatic processes. Many developing countries must also balance environmental commitments with urgent development needs such as poverty reductions, infrastructure expansion, and also economic growth. These structural limitations reduce their negotiating leverage and also frequently compel them to accept environmental rules that are designed by more powerful actors, even when those rules are poorly suit to suit to local conditions or impose disproportionate costs. And consequently, global South states often function as rule takers rather than equal partners in uh, global environmental governance. These power asymmetries are further reinforced by the close linkage between environmental compliance and access to economic opportunities. Compliance with international environmental standard is actually increasingly tied to eligibility for development loans, investment, and also climate finance and participation in global trade. Failure to meet these standards, of course, can result in restricted access to funding, reduced market opportunities, or reputational harm, creating strong economic pressure on developing countries to conform. While such mechanisms are framed as an incentive for sustainability, they also all provide as tools of indirect control, limiting policy autonomy and reinforcing dependency on external actors. Together, this uh, dynamic illustrate how global environmental governance is shaped not only by ecological concern but also by unequal power relations that continue to privilege developed countries while constraining the choices of the global south. Ladies and gentlemen, and beloved students, and all participants of this conference, as you can see, these case illustrations of power and injustice in environmental governance. For first is forest conservation versus indigenous land rights. What happened, like the forest conservation policies are widely promoted as essential tools for protection biodiversity and also mitigating climate change. But in other side, we can see that the establishment of protected forest areas are often creates direct tension with indigenous land rights. In many cases, conservation regime restrict indigenous communities' access to their ancestral lands, despite the fact that these lands have been sustainably managed through customary practices for generations. Forests are deeply intertwined with indigenous livelihoods, cultural identity, spiritual beliefs, and also traditional knowledge system. When access to these territories is limited or criminalized, in the name of conservation, indigenous communities face a threat to food security, economic survival, and also cultural continuity. This case illustrates how environmental protection measures, when designed and implemented without recognition of indigenous rights, can undermine justice and reproduce historical patterns of the marginalizations. The second is we can see that mining bans and also their impact of local livelihood as we can check, for example, mining bans and strict environmental regulation are often introduced to address concerns such as environmental pollution, land degradation, and ecosystem destructions. While these objectives are environmental significant, such restriction can have profound social economic consequences for local populations that depend on mining activities for employment and income. In many regions of the global south, mining forms the backbone of local economics, and sudden or externally driven bans can result in job losses, reduces household income, and of course, increased poverty in the global south countries. Without adequate transition plans, alternative livelihood, or social safety net, environmental regulation may place disproportionate burdens on already vulnerable communities. And the third, we can see that carbon offset projects and communities placements that actually this carbon offset project have emerged as a key mechanism in global climate governance, allowing high emission actors to compensate for their carbon output by investing in emission reductions initiatives elsewhere. Often in developing countries happen actually, then ladies and gentlemen, and beloved students and all participants of this conference, although these projects are framed as cost-effective and market-friendly solutions, they can restrict land use or lead to the displacement of local communities. Land design for carbon sequestrations may be removed from agriculture or communal. At the same time, the financial benefit generated by carbon markets frequently accrue to external investors, corporations, or project intermediaries rather than to affected communities. This can these situations can demonstrate how carbon offset mechanism can transfer the social costs of climate mitigation to the global south while enabling continued emission in the global north. Um, the next slides of my presentations, yes, here we will see then when green justice works. So conditions for just and effective environmental governance, uh, which should be seen from some elements to what is make this upholding of the works of this the green justice itself. We can check one by one, for example, like community-based environmental governance, that we understand that green justice function most effectively when environmental governance is rooted in community-based approaches. When local communities are directly involved in managing natural resources, environmental protection tends to be more sustainable, effective, and socially acceptable. Communities possess intimate knowledge of local ecosystems, seasonal patterns, and resource limits developed through long-term interaction with their environmental situations. Allowing communities to govern their own resources not only improves environmental outcomes, but also strengthens social cohesion and also uh, accountability. The second element is recognition of the customary land rights. The legal recognition of customary and traditional land rights is a fundamental pillars of green justice. Secure land tenure protection indigenous peoples and local communities from displacement, exploitation, and exclusion under conservation or development projects. When traditional land ownership is formally recognized, communities gain the legal authority to manage, protect, and benefit from the territories of them. And then what about the participatory decision making, which becoming one of the very essential to ensuring the legitimacy and fairness of the environmental governance,
Recording
involving
stopped.
effective communities in environmental planning, policy formulation, and implementation increases transparency, accountability, and also trust. The participants allows diverse perspective, including indigenous knowledge and local priorities. to shape the environmental outcomes. And the next things that have to be also considered to make uh, the green justice works here is technology transfer and also capacity building. Uh, as we can also consider that green justice also requires meaningful technology transfer and capacity building, particularly for developing countries in the global south. Environmental standards and climate commitments can only be met fairly when countries have access to appropriate technologies, financial resources, and technical expertise. Providing environmentally friendly technology, training, and institutional support enables developing countries to pursue environmental goals without sacrificing economic development or social welfare. Uh, we also will directly jump to the questions when it becomes green colonialism in the next slides. Yes, here. Um, uh, because it can see also the distortions of the environmental governance. um, First, like in the top-down environmental regulations, we can see that green colonialism emerges when environmental regulations are imposed through top-down approaches that exclude meaningful consultation with affected communities and states. Policies designed by international institutions, donor countries, or external experts are often implemented without adequate engagement with local population, ignoring their needs, knowledge, and also priorities. Uh, the second is ignoring social economic realities. We can see that another defining feature of green colonialism is the failure to consider local social economic realities. Environmental policies that do not account for poverty levels, employment patterns, and dependence on natural resources can worsen existing inequalities. In many parts of the global south, communities rely on farming, fishing, grazing, forestry, or small-scale resource extractions for their life or survival. When environmental regulation restrict these activities without providing viable alternatives or compensations, they can deepen poverty. Yeah, they can remains in the situation of the poverty, and economic insecurity. And then the third is criminalizations of traditional practices. Uh, as we can see, that green colonialism is also evident in the criminalizations of traditional and customary practices under modern conservation and also environmental laws. Activities such as shifting cultivation, subsistence farming, grazing, or the collections of forest product may be labeled illegal in protected areas, ladies and gentlemen, despite having been practiced sustainably for generations. These criminalizations delegitimize the indigenous knowledge system and portrays local communities as environmental threat rather than stewards of our nature. Then the fourth is environmental protections at the expense of the sovereignty. Finally, we can see that green colonialism manifests when environmental protection undermines state sovereignty and policy autonomy. Developing countries may lose control over environmental decision making when rules are externally imposed through international agreement, financial conditionalities, or trade requirement. Governments are pressured to adopt policies designed in the global north in order to secure loans, investment, or market access, even when these policies conflict with national development priorities. This dynamics limits the ability of the global south states to chart their own development path, and also reinforces dependency on external actors, reproducing an unequal power relations under the moral justification of environmental protections. So we can see that the legal I'm sorry, the legal implication of the green justice and green colonialism, how it actually tension with state sovereignty. And then we can see that one of the most significant legal implications of global environmental governance is the tension it creates with state sovereignty. When environmental policies and regulation are heavily influenced or dictated by external actors such as international institutions, donor state, or global financial organizations, which they are having the authority of a state to govern their own territory and natural resources can be constrained. So developing countries may find their environmental policy choices shaped by international standards and conditionalities rather than domestic priorities and democratic process. And what about the right to development? Strict environmental regulation also raise concern regarding the right to development, a principle recognized in international human rights law. And ladies and gentlemen, as we can see that for many countries in the global south, economic growth remains essential for poverty reduction, social welfare, and infrastructure development. When environmental rules impose severe limitation of industrial activity, resource extractions, or land use with the adequate financial and technological support, they can restrict economic opportunities need to improve living standards. This creates a legal and ethical dilemma between pursuing environmental protections and fulfilling the developmental rights of populations that continue to face structural poverty and inequality. And we can see the third element is self-determination of the communities, as we also understand that environmental governance has profound implication for the principles of self-determination, particularly for indigenous people and local communities. When environmental laws restrict how land and natural resources may be used, communities may lose the ability to decide their own development path, livelihood, and also cultural practices. What about the risk of neo-colonial regulations? Uh, Ladies and gentlemen, beloved students, and all participants of the conference, if these legal tensions are not adequately addressed, environmental law risks functioning as a modern form of neo-colonial regulation. And under this dynamic, environmental protection becomes a justification for extending control over the policies, resources, and development trajectories of weaker states. Legal frameworks that ignore historical responsibility, unequal capacities, and also local context may reinforce global hierarchies rather than promoting sustainability and also justice. So we can see that the next slide will talk about the global south response to unequal environmental governance versus south-south cooperation, or SSC. uh, Ladies and gentlemen, one of most important response of the global south to unequal power relation in environmental governance is the strengthening of south-south cooperations. Through this approach, developing countries collaborate with one another to share technology, financial resources, policy experiences, and best practices without relying heavily on institution or conditionalities imposed by the global north. The second is assertion of environmental sovereignty. Uh, the second key response is the assertion of the environmental sovereignty by states in the global south. Governments increasingly emphasize the right to design and implement environmental policies that reflects national priorities, development goals, and local ecological conditions. Uh, the next is about climate justice. Uh, Climate justice forms a central normative framework within the global south respond to global environmental governance. And of course, this concept calls for fairness in addressing climate change by recognizing the unequal distribution of climate impacts and also responsibility. We can see also another things is about common but differentiated responsibilities, or CBDR, closely linked to climate justice and the principles of a common but differentiated responsibility. Foundational concept in international environmental law here, which acknowledges that while all states share a common responsibility to protect the global environment, developed countries bear greater obligation due to their historical emissions. industrializations, and also greater financial and technological capacity. For the global south, of course, this what is a common but differentiated responsibilities serve as a legal and moral basis to demand equitable burden sharing, financial support, and also technology transfer. And uh, the next, I would like to talk about the balanced approach in a global environmental governance that you can see in a context-sensitive environmental law. A balanced approach to environmental governance requires the development and the implementation of context-sensitive environmental law. And then we believe that environmental policies must reflect local social, economic, cultural, and ecological condition rather than relying on uniform standard design for vastly different contexts. Uh, what about the equity-based implementations as a core elements of a just environmental governance framework? These policies inevitably create cost and benefit, and justice requires that this be distributed fairly across societies. This means ensuring that vulnerable communities do not bear this appropriate share of environmental burden, such as a loss of land, livelihoods, and also access to resources. And then inclusive global governance also becoming an essential overcoming the power imbalances that characterize current environmental decision-making structures. Step from the global south, and local communities must have the genuine and also meaningful voice in international environmental negotiations, policy design, and implementation processes. Genuine partnership, not conditionally becoming another what is patterns that we have to create to make this kind of balanced approach for saving the situation of international environmental cooperations. Environmental assistance, climate finance, and technology transfer should be grounded in a mutual respect, trust, and shared responsibility, not in coercive conditions. So finally, we are now in the conclusions. I would say a call to actions. Ladies and gentlemen, beloved student, and all the participants of this conference, uh, I would say that environmental law plays a crucial role in addressing global environmental crises such as climate change, biodiversity loss, and environmental degradations. However, this body of laws does not operate in political vacuum. Instead, it is deeply shaped by unequal power relation within the international system. And many dominant environmental norms, standards, and regulatory framework are, designed by actors of the global north and subsequently imposed in the global south through international agreements, development, finance mechanism, and trade requirements. And this process often creates significant pressure on developing countries, of course. Like today, what happened in country that have to comply with all the environmental standard that might not align with our socioeconomic realities, capacity of our institution, and also development priorities. Uh, we do believe that by achieving genuine sustainability, therefore, require a fundamental shift in how environmental governance is conceptualized and practiced. And environmental law must move beyond one-size-fits-all solutions and embrace context-sensitive approaches that reflect diverse social. Uh, and I believe that this calls for action from state, international institution, policymakers, and also civil society alike. Will also try to make this development of the social protections. I mean environmental and social protections for the people in the South, global South countries. Ultimately, the future of global environmental governance depends on a shared commitment of us to ensure that environmental protections advance both ecological sustainability and also global justice, rather than reproducing inequality in the name of the what so called as the green agenda. So I think that's all my presentations. Thank you very much for all of your attentions for today. Unfortunately, I cannot just uh, 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 have this what is a direct conversation for you all, because now I have to visit another universities in other country. So I'm so sorry that I can uh, make this question answer with you all. So good luck for this conference for you all, especially for the students. Have a good day. Thank you very much. And again, thank you very much for all the committees who already invited me to be a part of this conference held by Universitas Muhammadiyah Bengkulu. Billahi fi sabil haq, fasabiqul khairat. Assalamualaikum warahmatullahi.
I'm sorry. Thank you very much, Dr. Gunawan, for your valuable insight about green justice or green colonialism, environmental law, and power in the global south. And ladies and gentlemen, before we proceed to our next session, allow me to respectfully acknowledge the presence of the Mayor of Bengkulu City, Bapak Dedi Wahyudi. Welcome to the second International Conference of Law, Politics, and Policy. Thank you very much, Bapak, for joining us today. Ladies and gentlemen, our next speaker is Mr. Rizaldi Angriawan, SHLLM. In addition to his academic career, Dr. Angriawan has professional experience as a corporate legal counsel and is a registered advocate with the Indonesia Advocate Association, or PERADI. He has participated in various international Netherlands, Spain, and Croatia, focusing on international and criminal law research. He is also actively involved in several organizations, such as Pemuda Muhammadiyah Europe and the Mediterranean, PCIM Hungary, and Pemuda ICMI Europe. In both national and international, Dr. Angriawan has published in the International Journal. Everyone, please welcome Mr. Rizaldi Angriawan.
Well, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Am I audible?
Yes, sir. We can hear your voice. Thank you.
Well, that's nice. First, I'd like to share my can you confirm whether my PowerPoint slide is visible enough to all of the audiences? Is it visible, my PowerPoint?
Yes, sir, we can hear your voice.
I mean, my PowerPoint,
Oh,
is it
yeah.
visible? Can you see
It's visible,
PowerPoint that I
the
have?
the slide.
Well, thank you.
Yeah.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Distinguished colleagues, respected organizers, my dear students, ladies and gentlemen, and good morning for all of you from Hungary. Here in Hungary, it is almost 4 a.m. in the morning, very early morning. And first of all, I'd like to say thanks so much for these invitations to be able to deliver a speech or presentation in this international conference delivered by Universitas Muhammadiyah Bengkulu. I would like to say thank you so much for Dr. Andi Azhar for inviting me. Actually, he was my chairman of PCM Taiwan when I was a member of PCM Taiwan. He was the chairman at the time. And I would like also to express my gratitude and acknowledgement to the university leaders, directors of the Universitas Muhammadiyah Bengkulu, Dr. Susianto, for letting me to deliver these presentations. Also to the Dean of the Faculty of Law, Universitas Muhammadiyah Bengkulu, Dr. Rangga Jaya Nyarto. This is an honor for me, a great honor for me. This is a valuable opportunity and occasions to be able to share the discussions among the legal scholars in Universitas Muhammadiyah Bengkulu. So, directly to the topic, today I would like to talk about the issue of the ecocide and criminal liability. There is an important question that should be addressed here and should be answered by many legal scholars who involve or keen in the issue of the environmental law, the criminal law, as well as the issue of the deforestations and etc. I would like to invite you to think about that the environmental protections in this regard is not only as a scientific or political issue, basically, but also in the modern times, it was also considered as a criminal law issue. Well, but before we are going to deeply discuss about the materials, I would like to introduce myself. My name is Rizaldi Anggriawan. I earned my bachelor degree in Universitas Muhammadiyah Yogyakarta. And after that, I continued my study at Asian University, Taiwan, at the Department of Financial and Economic Law. And currently, I'm doing my PhD, my doctoral degree in the University of Szeged under the Stipendium Hongaricum Scholarship. And probably this would be my last year doing PhD, hopefully in the early or in the middle of the 2026 would be I could defend my thesis here in the Hungary. I'm also a lecturer in Universitas Muhammadiyah Yogyakarta precisely in the Faculty of Law, and I'm also serving as the Corporate Legal Counsel of Employee. It is one of the human resource enforcement systems company which established in the Jakarta. I'm also a registered and licensed advocate by the Indonesian Advocate Association or PRADI, Perhimpunan Advokat Indonesia. And I also have some international and national experiences regarding some activities and events conducted by some universities and some organizations in some countries, for instance, in the United States, in the Norway, Netherlands, Spain, and Croatia. And I'm currently
Recording in progress.
Chairman of Pemuda Muhammadiyah Eropa and Mediterranean and Chairman of Majelis Tarjih and Tajdid PCM Hungary, and a coordinator for the International Criminal Law Research for the Ikatan Cendekiawan Muslim Eropa. I actively publish my manuscripts and articles, also publish my books in reputable journals, which commonly indexed by the Scopus or Web of Sciences. Well, ladies and gentlemen, talking back to the topic of the ecocide and the issue of the criminal liability, the first question that might be arise in this topic is, what is ecocide? What is ecocide? So please take a moment to look at that word first, ecocide. It sounds like that these terms, it sounds like dramatic and sophisticated, but what exactly does it mean by the ecocides? So actually, ecocide, the term of ecocide here comes from two words in it. You could see that there is eco in one side, and another side there is site. So eco meaning environment or home, and site meaning skilling. So simply put, ecocide means the killing of our natural home, the killing of our natural home. And talking about the ecocide, essentially, ecocide means that the mass damage and destruction of nature damage that is so severe, so widespread, and so long lasting that it significantly reduces the peaceful enjoyment of the ecosystem by the inhabitants. And the victim of the ecocide in this context is very unique because compared to other delicts or other crimes in the context of criminal law, that is the victims more are humans, the victims of the ecocide itself is the nature itself. So unlike the traditional crimes, ecocide recognizes that nature has intrinsic value, not only economic value. And historically, you could see from the slide that the term of ecocide actually has been around for decades, has been discussed by many legal scholars for decades, and it tracing back to the Vietnam War in 1950s or 1960s something. And the word ecocide actually was first used in the late 1960s by the American scientists. Here you could see in the slide that Professor Arthur Galston is one of the most popular plant biologists at the time that introduced the term ecocide. He introduced ecocide to describe that the massive and deliberate environmental destruction committed by the US military in Vietnam. And the reason or the primary driver of this concept was Operation Ranch Hands. You could see from the slide in the top right corner. This Operation Ranch Hand actually was conducted was committed by the U.S. military in the early of 1960s to the early of 1970s. And the U.S. military committed the herbicidal warfare program at that time. The goal or the objective of this commission was to remove dense jungle cover or doing defoliations used by the Vietnamese fighters. And the goal is to destroy crops that supplied them. And the next questions that might be interesting is why environmental destruction is a criminal law issue. So basically, environmental destruction today is no longer distant. You could see from the reality right now. And it's no longer abstract problem. Everyone in the world could see what's happening in the world right now. We see that forest fires create toxic haze across national borders, and rivers also polluted to the point where communities cannot drink the water, and deforestation that destroys biodiversity and indigenous livelihoods as well. And you could also find that climate change cause floods, droughts, and food insecurity. What's happening right now in the three provinces in Indonesia, in Aceh, in Sumatra Barat, in Sumatra Utara, all of these things are happening at this time towards our brothers and sisters and at those three provinces. And traditionally, the law has treated these harms mainly as administrative or civil matters. the companies are fine. The companies who infringe these regulations or this crime are fine. They are being imposed by a significant fine. And the license also could also be revoked, and the compensation uh, must be paid as well. But do you know, um, the question is here, are these legal responses is enough when the damage is irreversible, when the damage is permanent, when the damage cannot be repaired or unrepairable? So in criminal law, we punish conduct that causes serious harm to the society. And environmental destruction on massive scale, of course, and certainly cause harm not only to individuals, but also to the entire communities, to the entire generations, even the future generations, and even the stability of the planet itself, our beloved planet here, the Earth. So this is why, many scholars, many activists, environmental activists, and legal professionals increasingly argued that severe environmental destruction should be treated as a serious crime, not merely as a regulatory violation. And talking about the criminal law in relations with the issue of the ecocides, we must break down the ecocide under the criminal law concept. So let us break this down using criminal law concept that you might already be familiar with. I think of the students and professors and doctors here already knows about the concept of actus reus and mens rea. So in the context or in this regard, in the issue of ecocide, the first element that must be fulfilled by the offender of the ecocide is the actus reus, which means the physical act that may include, in the context of the ecocide, is the large-scale deforestation, for instance, the destruction of coral reefs, or maybe the toxic waste dumping, or massive pollution of air or water or soil. So these all is a physical act of the offender and could be translated or interpreted as the actus reus. And the second element that must be met is the mens rea. The mens rea means the mental elements. But, the mental element is not always about the intention. In many proposed definitions by many criminal law legal scholars, the knowledge or the recklessness is also sufficient to be considered as mens rea. So in other words, in the context of the ecocides, we could take the example or illustrations when the perpetrators or the offenders now knows that the environmental harm will occur in the future, or consciously disregards or ignore a high risk of serious damage, so they could be considered have a mens rea in their activity. So from criminal law perspective, this also raises fascinating questions, important questions, whether who can be held criminally responsible in the ecocide, and whether corporate executives can be also be prosecuted in this regard, and whether state leaders can also be held accountable, and the method on how do we prove how do we prove causations and intent in environmental cases. So international criminal law basically has always evolved slowly, but history shows us that crimes once considered political or unthinkable, like for instance, we take the example of genocide, which in the past was rejected by many countries, by many states, but the current situation now, it is universally condemned by many states and people. So in this context, ecocide may follow the similar path as like genocide as well. And now talking about ecocide and international criminal law. So at this point, there's important questions that might arise among you that whether ecocide already a crime under international law? Unfortunately, the answer is not yet. It's not yet regulated under international law. Currently, if we see to the Rome Statute of the International Criminal Court, there are only four core crimes under Article 5. The first is the crime of genocide. The second is the crime against humanity. The third is war crimes. And the fourth, the crime of aggressions. And the issue of environmental destruction appears only in a limited way, and mainly in relation to war crimes. We could take an example of the Vietnam War that I have discussed in the beginning of the presentations when they did this herbicidal warfare program committed by the US military at that time. And talking about the legal definition of ecocide, this is one of the imperative discussions that must be taught by us. In 2021, there is an independent expert panel led by Jojo Mehta from Stop Ecocide Foundations. This independent expert panel, they propose a legal definition of ecocide as potential fifth international crime under the Rome Statute of the ICC. You see here, I put the pictures of the independent expert panel, and the left photo is Jojo Mehta. She is the leader of the Stop Ecocide Foundations, and she convened all these expert panels to a single meeting to formulate a legal definition of ecocides. And at that moment, the panel describes ecocide as unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And talking about the criminal law concepts, we could see key legal elements in their proposals or in their legal definitions proposals. We have discussed about the issue of actus reus. So if we see from definitions delivered by this panel, we could see the actus reus from the word of actions or omissions causing severe environmental damage. And the mens rea itself, we could see from the knowledge of a substantial likelihood of such damage. You could see from that definition there is a word knowledge here, so it could be regarded as the mens rea element in the legal definition as proposed by the panel. And the other elements also important to be put and met by the offender of the ecocides, which are severe, widespread, and long-term, which are defined to capture lasting or extensive harm. This draft actually also includes recommendations to add a new preambular paragraph to the ICC, which recognize the importance of protecting the environment. So this is actually the recent updates about the ecocides in 2021, and hopefully in the future we would see a more progressive update from them. And talking about what about the other jurisdiction? Have they adopted the ecocide as well? So fortunately, several states, particularly small island nations like Vanuatu, Maldives, Fiji, and Samoa, that are vulnerable to climate change, they support this initiative. And also some big country or jurisdictions have already introduced domestic ecocide laws, such as Spain, Scotland, Belgium, France. They also adopted these ecocide laws into their own or into their domestic legislations. For instance, in France, they have established the Climate and Resilience Act of that has been enacted in 2021. And These legislations, this act actually stipulates to punish those who intentionally commit acts that cause serious and lasting damage to the environment. And the lasting damage here is defined as a harm likely to persist for at least 7 years. So, if it is a permanent environmental destructions that persist for at least 7 years, it could be defined as the ecocide at that country. And penalties for this individual is not minor. It could include it to 10 years of imprisonment, and the offender of this can be subjected or imposed to the fine until 4.5 million of euro, which can be increased up to 10 times the profit derived from the offense. So this is a major legislations enacted by the France parliament. And what about Indonesia? Where Indonesia potential ecocide target? Indonesia, based on recent data as revealed by Greenpeace, there was 15 million hectare loss of natural forest cover in Indonesia between 2001 until 2023. And there was also 2.13 million hectare, the extent of forest and land fires in Indonesia. It is data revealed by the Greenpeace. And there's also data covered by the Auriga Nusantara that compare the deforestations between 2023 and 2024. And the result is there was a massive increase of the deforestations in two regions, in Kalimantan and Sumatra, especially in the Sumatra region. So basically, Indonesia provides a powerful case study for discussions. Indonesia is one of the most, of course, biodiverse countries with vast forests, oceans, and also the ecosystems. But, at the same time, it has faced serious environmental challenges. But however, many cases involve in Indonesia, unfortunately, it results long-term and irreversible damage or permanent damage. And it results to cross-border impacts, many deforestations or many land burnings that is happening in the Sumatra Islands has the huge impact, cross-border impacts to Singapore, to Malaysia, and our neighboring countries. And also they have committed many corporate and systemic wrongdoing. So these all facts leads us to critical questions. When environmental harm reaches a certain scale, should it remain a domestic regulatory issue or become a matter of international criminal accountability? And this is very interesting question that should be answered by our stakeholders, by our public officials and any academics. And from a criminal law perspective, the Indonesian case highlights the difficulty of proving menstrual in corporate structures. Many corporations that involved in these environmental destruction is very difficult to be proven by our law enforcers. And addressing power imbalance between communities and corporations also one of the important point. The margin between the high level corporations and the lower communities in Asia was making the situation worse than before. And the issue of balancing economic development and environmental protection is also one of the important points that should be addressed by many public officials, many stakeholders in this regard. So ecocide as a legal concept challenges us to rethink these issues better in the future. And what about our Indonesian domestic legal framework? Fortunately, Indonesia has a specific law about the environmental protection and management. It is regulated in law number 32 of 2009 that regulates about the environmental protection and management. And this law itself regulates about the issue of the environmental damage. We could see from the Article 1, paragraph 16 and 17. And in the Article 116, it also regulates about this, the offenders of the environmental damage. Once there is an environmental destructions committed by the business enterprises, who must responsible towards those crimes. Actually, it is regulated in Article 116. 16. And this law actually also regulates about some major criminal conviction as well. For instance, in Article 19.8, it regulates about the violations of ambient air or water quality standards, which the offender of this would be subject to 10 years of imprisonment and would be imposed of maximum 10 billions of fine. But even if Indonesia have environmental protection and management law, you know, there is still limitation in the enforcement and the implementation of this because this law provides criminal sanction for certain acts of environmental harm, but it doesn't recognize ecocide as independent crime with broader legal reach comparable to the proposed ICC definitions. So cases that might resemble ecocide might still fall under the environmental offenses rather than ecocide category. And maybe there is questions that rise among you all, that why does International Criminal Court need to recognize ecocide as international crime when most states already have their own environmental law? Indonesia, they have their environmental law. Singapore, Malaysia, Thailand, you could mention any major states in this world, they have their own environmental laws, mostly. But why does International Criminal Court need to recognize ecocide as international crime? At least there are 4 reasons why we should promote the ecocides to be considered by the International Criminal Court. The first is about the scale and nature of the crime. First, ecocide differs fundamentally from ordinary environmental offenses because, the scale and the transboundary nature is different. And large-scale environmental destruction often produce widespread and long-term impacts that do not stop at national borders. They would cross the borders of Indonesia, for instance, to Singapore, Malaysia, Thailand, and any neighboring countries, Brunei Darussalam. And air pollution, climate change, ocean pollution, and massive deforestation in one country can affect ecosystem of other states. It could also affect the other animals, inhabitants in other states. And national environmental laws are limited by territorial jurisdiction. Indonesia have their own environmental law, but it is imposed to Indonesian citizens. And it's also happening in other regions. So the ICC here, by contrast, exists precisely to address crimes that affect the international community as a whole. So ecocide is proposed as more serious crime. It also can be comparable to the genocide, the crime against humanity, the war crimes, and the crime of aggression. And unfortunately, most domestic environmental law focus on more administrative sanctions, monetary fines, or some restricted, relatively light criminal penalties. So these tools are often inadequate when, confronting a systemic, a massive and irreversible ecological destruction. And the second reason is the gaps in national law enforcement. There are various and serious enforcement gaps at the national level. In many countries, environmental law enforcement is vulnerable, like to political pressures, the issue of economic interest, development agendas, and corporate influence. The governments of those countries may be unwilling or unable to prosecute powerful corporations or high-level decision makers whose activities cause large-scale environmental harm. So this is where actually the principle of complementary becomes crucial in this context. So under the Rome Statute, the ICC may exercise jurisdiction when the states are unwilling or genuinely unable to carry out prosecutions. And additionally, the national legal instruments that is almost adopted by many states, they more focus on licensing, compliance procedures, and technical violations. And they are not designed to address systemic ecological destruction caused by multinational corporations or step-back projects that threaten environmental sustainability itself. This is the second reason. And the third reason is it is important to shift in legal paradigm from anthropocentric to ecocentric. So adopting ecocide would represent a fundamental shift in legal thinking. So traditional international criminal law is largely anthropocentric, where it focuses on harm to humans. Environmental damage is usually prosecuted only when it directly causes human suffering or death or maybe displacement of the humankind. Meanwhile, the proposed crime of ecocide moves toward a more ecocentric approach, where it recognizes serious, widespread, or long-term damage to the environment itself as criminally relevant, even when immediate human harm is not the central element. And the fourth reason here that could be addressed is the deterrence. It's about the deterrence to create a global preventive effect, that the recognition of ecocide would serve a powerful deterrence function. If ecocide becomes an international crime, it would send a clear message to all the states, to all the countries and nations, that the corporate leaders, the government ministers, the policy decision makers, that severe environmental destruction may result in international criminal responsibility similar to war crimes or crimes against humanity. So this international stigma and potential liability could influence corporate governance and also strengthen environmental due diligence and encourage states to prevent ecological harm before it reaches catastrophic levels. And to conclude these presentations, ecocide represents severe environmental destruction that exceeds administrative or civil liability and justifies criminal accountability. And also, by recognizing ecocide as international crime, it would close accountability gaps where domestic laws fail or are unwilling to act. And the inclusion of ecocide under international criminal law would also strengthen global environmental protection and reinforce state and corporate responsibility. And above all these facts and thoughts, I want to raise a simple question that might open our eyes and mind. That is, if the law recognizes that killing one person is a crime, should also the law recognize that destroying an entire ecosystem, for instance, like forests, rivers, oceans, and the lives of the people depending on them, is a crime? So these questions and statements wrap up my presentation today. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.
Wassalamualaikum warahmatullahi wabarakatuh. Thank you very much, Mr. Rizaldi Anggriawan, for your valuable insight and a very eye-opening knowledge that ecocide should be the international crime. And now, we will now move on to the discussion and question and answer segment. For all the participants that wish to ask the questions, you can raise your hand or you can write your question in the comment section. And be mind that you need to introduce yourself by name and your affiliation, and then you can ask your question. Thank you very much. Maybe before we wait for the question, how are you, Mr. Rizaldi?
I'm good. I'm doing good right now. Thank you.
Alhamdulillah. Yeah. Are you in Hungary right now?
Yes, I'm hungry
Oh,
now.
is it already night there?
No, it's very early morning now at 4
Okay.
30 something subuh prayer.
Yeah. We were very grateful for your presence, sir. Thank you.
Thank you.
Maybe before the questions, I would like to discuss again about the point from the Mr. Jordan Gunawan presentations, which is about the green politics, green justice, and green colonialism. This discussion studies green justice and green colonialism within global environmental crises such as climate change, deforestation, and food insecurity. While international environmental law has emerged in response, it remains largely shaped by the global north, often placing disproportionate burdens in the global south countries. And green justice raised critical questions about equity and equality, who benefits from environmental governance, while green colonialism exposed how environmental policies can reproduce unequal power relations through resource exploitations and conditional investment. And from the presentation of Mr. Rizaldi Angriawan, it discussed about the ecocide. Ecocide and criminal liability. Should ecocide be an international crime? It's mainly discussed about ecocide comes from the words eco, mean environment, and side mean kill, meaning the destruction of killing or of nature. The term was introduced by the Professor Arthur Dalston that described severe environmental damage that leads to ecological chaos and destruction. Nature is regarded as a unique and valuable entity. Many activists and professionals argue that environmental destruction should be considered a serious crime because it fulfills key legal elements, namely actus reus or the acts, and mens rea or means intent or awareness. However, environmental destruction is not yet regulated as a crime under criminal law, international criminal law, raising an important questions of whether ecocide should be recognized as an international crime to ensure accountability and environmental protection. There is someone who typed in the comment, maybe Prasetyo, UMB Fakultas Hukum. If you want to ask the question, you can open the microphone or just write your question in the comment section.
Oke,
Ya.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
My introduce myself. My name is Feby Iqbal. I'm from Social and Political Science, University of Muhammadiyah Bengkulu. I have one question for you, for Dr. Rizaldi. Social factor determine community resilience in responding to environmentally based green policies. What 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 social factor determine community resilience in responding to environmentally based green policies?
I'm sorry, can you just write your question in the comment section because I cannot hear your voice clearly. Thank you. What social factors determine community resilience in responding to environmentally based green policies? Maybe we can continue to the second question first before Mr. Rizaldi will answer the question.
Well, I can address the question right now, actually. Can you hear my voice? Is it
Yes, sir.
clearly
Yes, we
now?
can hear your voice.
Well, actually talking about the community resilience in response to environmentally based green policies, we could see some several interconnected social factors. For instance, like the issue of you know social capital, where the quality of the social interconnections or communications, the relationships, including strong community networks, social cohesions, and was a trust among residents and in institutions, for instance, like local governments or NGOs. This is one of the important points in the social community resilience. And the second thing I think that is also can be important factors is the access to us to the assets and resources. So basically, the availability and accessibility of various or diverse assets, including, financial, technological, or physical infrastructures like, schools, roads, healthcare, and natural capital. These all are things that is fundamental for the society. And communities with this greater access actually to a variety of resources are generally better equipped to invest in adaptive measures. And I think these all factors, the access to asset resources and the social capital is becoming an important or fundamental thing to be considered as a factor for community resilience. I think that's my answer.
Very much, Mr. Rizaldi Anggriawan, for your answer. Maybe we can continue to the next question from Prasetyo. You can ask your question.
Baik, good morning, Mister.
Good morning.
Thank you, moderator.
Yes.
Let me introduce myself. My name is Prasetyo, at 5 semester student in the law study program at Muhammadiyah, Bengkulu. I would like university to ask about the material that has been delivered by Dr. Rizaldi Anggriawan. How can uncontrolled environmental destruction affect like 3B my
Excuse me, Prasetyo, can you continue your question? Because I think it's being cut. So what exactly that you ask? Can you elaborate more, Prasetyo?
How can uncontrolled environmental destruction affect human rights? The REBI making it a legal issue.
Would like to clarify, maybe what Prastyo means is how can environmental destruction can affect human at general, maybe. Maybe Mr. Rizaldi can answer the question.
Well, actually, this question has nothing to do with the presentation that I have delivered before, but I'm trying to answer the questions. Well, basically, as a human beings, we are living in side by side by the environments, and we cannot separate our lives with the environment that we live in this world. So basically, once there is environmental destruction or environmental damages committed by a particular or certain offenders, of course, it would influence more or less, major or minor, towards our well-beings or our lives itself, directly or indirectly. So I think it is therefore important for every stakeholders in the scope of a particular nation or a certain nations in a small region as well to begin to rethink the issue of the environmental protection in this era, because we have been alerted by our God by many environmental events in couple weeks in these days. You know what's happening in in Sumatra, what's happening in Jawa, in Kalimantan, or many floods, many droughts, many earthquakes happening right now, and it is resulted by the hand of the human beings itself. So we have to rethink about this in the future. I think that's it.
Thank you very much, Mr. Rizaldi, for your great answer. And maybe I would like to ask personally, because I have a question. I was a international relations student. I was graduate from that degree, and as we know that international law is not yet considering the environmental destruction as one of the international law. So what do you think, sir, to make environmental destruction as the international crime? What we need to do as Indonesian citizen, maybe what can we that we can do to participate to make this happen, because we know that environmental destruction is very important to an important issue to be considered by the government, whether or not by the UN itself. What do you think, sir? Thank you.
Well, thank you for the questions. Well, basically, as I have delivered just now that actually what we do now and what the other environmental activists do now, legal scholars and many stakeholders that key into the environmental topic, uh, they focus more on how to include or make the important points to the ICC or the International Criminal Court to recognize environmental damage or environmental distractions as an ecocide crimes. And this one of the major milestones that could be appreciated by us, not only as an environmental activist, but also as an Indonesian. And if there's a question, why it is very difficult to establish an ecocide as an international crime, because many states or countries that involve in the environmental distractions, we could not say that Indonesia is not part of this ecocide target. Indonesia is one of the ecocide target because there are data as revealed by many NGOs, by many organizations reveal that Indonesia is part of the countries that conducted environmental damage or environmental destruction, which is very massive. And but to establish an ecocide to an international criminal court, it is very difficult because many public officials, many state stakeholders, they think that once the International Criminal Court adopts the ecocide as the fifth crimes under the Statuta Roma or Rome Statute, so their sovereignty of the state would be disturbed. The sovereignty of the states would be intervened by the other states. So it would also in line with the issue of the development of the states itself. So the development of states in many developing countries, they are more focused on the exploiting the environmental resources like mining of gold, mining of gases, mining of every minings. We have any kind of minings in Asia. Once the ICC or International Criminal Court, they adopted the issue of the ecocide to the fifth crime of crime in the Rome Statute. So the other countries, the other states would claim or allege Indonesia as one of the ecocide offender, and this will result to the conviction of the state or officials like maybe the president or the minister of the forestry and other parties that might be alleged to conduct this type of crime. So I think it is very difficult to impose or to establish the ecocide as the fifth international crime, but we always try the best to include this topic to the fifth international crime in the ICC. Thank you.
Thank you very much, Mr. Rizaldi, for your answer. Maybe because we have the time limit, maybe I will limit the question, maybe just two more. Like right now, there is a question from Chika Alicia Putri from the Sociology Study Program. She asks, to what extent should states be held internationally responsible for acts of ecocide occurring within their territories, particularly in the context of Indonesia, where large-scale deforestation, extractive industries, and environmentally harmful development projects continue despite existing national environmental regulations? What do you think about it, Mr. Rizaldi, about this question?
Well, I would like to refer to the legal definition as proposed by the expert of the panels as convened uh, Maria in the UK in 2021, that the definition of the ecocide that is being proposed by this panel actually is about the ecocide is relates to the unlawful or wanton acts that committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So if we refer to this definition, actually, if in the context of Indonesia, so once there is unlawful or wanton acts that is being happened or conducted by any parties, individuals, or perhaps business entities, committed these unlawful or wanton acts in Indonesia.
I'm sorry, sir. I think your microphone is being mute.
Well, okay, okay. Sorry, but okay. Well, I would like to actually to address these questions. I would like to refer to the legal definition as proposed by the Stop Ecocide Foundations. When there was in 2021, there was expert of legal panels convened by Jojo by the chief of the Stop Ecocide Foundation, and this panel they formulated a brief and but effective legal definition about the ecocides. They defines that the ecocide as unlawful or wanton acts committed with knowledge. So once there is a substantial likelihood of severe and either widespread of long-term damage to the environment being caused by those acts of the environmental destruction, for instance. And in the context of Indonesia, so if we see to the fact that there is a business entity, for instance, or individuals committed unlawful or wanton acts with the knowledge that this commission or this activity would result to a severe and widespread or long-term damage, it could be considered as ecocide. But however, back to the topic, back to the current situations, ecocide is not part of our legislations. So we couldn't find any legislation in Indonesia that discuss or that stipulate that ecocide is part of the our regulatory framework or legal frameworks. So perhaps in the future in Indonesia, but I don't know whether Indonesia would support this ecocide because it's quite difficult to establish this, where many people have their own interests, political and financial interests in this regard. I think that's my answer.
Thank you very much, Mr. Rizaldi, for your answer. And there is a very interesting question from Mr. Sinung Mufti Hangabe. So he asked about how does the ontological positioning of nature as an object of law contribute to the erosion of ecological life values, and how can legal reconstruction based on ecological justice restore the recognition of ecological life values within contemporary legal system? What do you think about this question, sir?
Well, actually, this is very interesting questions, but I think it's not a part of my expertise to answer these questions about the ontological positioning. Especially it relates to the issue of the ecological life values. I think it more relates to the presentation of Associate Professor Jordan Gunawan rather than my presentations. So I would leave it for Pak Jordan, perhaps, but unfortunately, he's not here, right?
Okay, thank you, sir. That's okay. Maybe we will move on to the next question. So from Muhammad Rifai, a law student at Universitas Muhammadiyah Bengkulu, what do you think, sir, about how was the Sumatra disaster handled from the perspective of Indonesian positive law? What do you think,
Well,
sir?
actually, it's a simple question. It's from Rifai. It's a simple question, Rifai, actually, to handle the disaster of Sumatra. Our existing legal frameworks, we have discussed that Indonesia have own legislation on environmental protection and management as regulated in law number 32 of 2009. But unfortunately, we have a good legislations, we have a positive law about this, and this law actually have stipulated some major points, including the environmental damage, the environmental destructions, and other type of crimes in relations with the environmental crime. But however, it is nonsense to have a good positive law, but the enforcement is not as good as the positive law itself. So you could translate or interpret my answer by your own.
Thank you very much, Mr. Rizali, for your answer. Maybe one more question, the last question from Novelia Firsty. You can ask directly maybe because you just type in the comment that you want to ask. Please, the floor is yours. Or maybe if you want to ask from the chat box, you can write down your question first, because this is the last questions. I need to remind all of the participants. Oh, I think she is already typed in the comment sections. She said that my name is Novella Firsti from Universitas Muhammadiyah Bengkulu, Faculty of Social and Political Science, Public Administration Study Program. With your permission, I would like to ask a question. This question is addressed to Mr. Rizaldi Angriawan. The question is, what challenges and opportunities arise in the implementation of green policies within public administration? What do you think, sir, about this question?
So what challenges and opportunities arise in the implementation of green policies within public administrations? Well, actually, this is one of the challenges that arise on the context of the green policies within public administrations. It is, I think, not only in the context of the green policies, but the other policies as well. Indonesia has many departments or state organs that overlapping between one to another. So that they have their one department or one state organ, they have almost identical or similar jobs or functions that may overlap the other departments or state organs. This is one of the challenges. And the other challenges that might arise also the working culture of our people, that many of the Indonesians workers, especially that work for the state or civil servants, their working culture is not as good as the in the private sectors. So it is very common and it is based on the data as revealed by many organizations or NGOs that the working cultures of the public administrators who works in the governments is not is being criticized by the public. So to develop the green policies, we need good institutions, the good state organs that's not being overlapped one another, and we also need the human resources that is have a good integrity, that have good work ethic, and etc. etc. I think that's the answer.
Thank you very much, Mr. Rizaldi Anggriawan, for your amazing answer about all of the questions. I think it's exceed 5 questions, I think. And before we conclude, I would like to express my sincere appreciation to our distinguished speakers for their valuable contributions, Mr. Yordan Gunawan and Mr. Rizaldi Anggriawan. Thank you very much. And I would also like to thank all the participants for their active engagement throughout the sessions that already asked the questions. With that, this concludes our sessions. Kind reminder for all the participants that we will continue our session today at 1 p.m. Jakarta's time. Please join these sessions because I assure you that our speaker is as amazing as the session speaker. Me, Exarefa Amalia, would also to say sorry if there is any mistake in these sessions. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Wabarakatuh.
Mengingatkan kembali untuk para peserta di Zoom meeting, kita akan kembali lagi memulai lagi sesi kedua pada pukul 1 siang. Tolong boleh join pada waktu tersebut karena masih akan ada sesi selanjutnya. Terima kasih.
short Kang, keep short sebentar lagi.
I learned that ChatGPT works best with detailed prompts, but I hate typing them. So instead, I dictate them using Whisper.
والغم والهنا أشفى جميلة شرف فؤادي وأنسى بها فرحان أسد لا يدى للفديلة بما وأنا فما يوحشي للفضيلة يبي شفاء لنفوس العليلة يا بختي بالنانا منه ملا فنجان يبي شفاء لنفوس العليلة يا بختي بالنانا منه ملا فنجان وحدنا دندنا وحدنا دانا وحدنا دندنا وحدنا 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 دندنا وحدنا دانا وحدنا دندنا وحدنا ودانا وحدنا دندنا وحدنا دانا وحدنا دندنا وحدنا ودانا وحدنا بعد الويا فيها رويا وخيول زين وكلنا يريف دفيلة دم اللهاجر ولا بالحبيلة ويسليه الله فارسنا الفرجان دم اللهاجر ولا بالحبيلة ويسليه الله فارسنا الفرجان وحدنا دندنا وحدنا دانا وحدنا دندنا وحدنا 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 دندنا وحدنا دانا وحدنا دندنا وحدنا ودانا وحدنا دندنا وحدنا دانا وحدنا دندنا وحدنا ودانا وحدنا
If you haven't used an AI agent yet, this should be your first one. I get asked hundreds of questions every single day that before I had to answer manually. Questions like these are a hidden time sink on companies' productivity. You've got one person waiting for an answer right here who may be stuck, and you've got other people who get interrupted to have to answer people on a day-to-day basis. But what if AI could solve this? The real challenge is that answers to these questions require deep company knowledge, something that AI is not good with. Until Brain, since our team communication and company knowledge is all in ClickUp already, you just turn it on with one click and the autonomous answers agent works automatically. This AI agent now chimes in with the answers, like this answer that's based on our company handbook, right? Or this answer that's based on a project that's already in flight, or this one that's pulled together from insights and answers that already exist across the entire workspace. The thing that makes this different than asking Google or ChatGPT is that the agent is an expert for your company. This agent knows your processes, it knows your brand guidelines, it knows your styles, and it certainly knows all of the context that you've chatted about and worked on in the past. It's able to answer these questions in real time while preserving privacy and permissions for every single employee. ChatGPT only knows what you give it, what you feed it in the prompt. The vast majority of the value you get from AI is from the context, the data, which is what ClickUp Brain excels at. Now, 90% of those questions are answered automatically by the autonomous answers agent. To get this agent, go to any channel and click up chat and literally just click one toggle to turn it on.
Wow, Manage WordPress Hostinger punya 3 fitur fantastis untuk website kamu. Pertama, ada CDN untuk loading konten secepat kilat. Kedua, ada Light Speed untuk buat loading websitemu lebih ngebut. Ketiga, ada fitur Object Cache yang buat websitemu 3 kali lebih cepat. Performa website di Google Core Web Vital pasti jadi lebih bagus. Hacker, siapa takut? ada fitur pendeteksi malware, ada firewall, dan proteksi DDoS. Website sudah pasti aman, SSL langsung aktif dan terinstall otomatis. Semuanya gratis, tis-tis. Plus, proses update dan backup website sudah otomatis. Dapat notifikasi website error, kami bisa bantu atasi errornya. Belum ada ide untuk konten website? Sekarang Hostinger ada tool AI baru untuk bantu kamu buat konten. Sudah punya website? Pindahin ke Hostinger aja. Prosesnya cepat, otomatis, dan gratis loh. Hubungi kami kapanpun kamu perlu bantuan. Ada lebih dari 2 juta orang yang puas dengan hosting kami. Coba cek dan buktikan sendiri. Kapan lagi ada manage WordPress hosting selengkap ini? Buruan pilih paket Hostinger sekarang. 3, 2, online.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, distinguished speakers, respected participants, beloved students, and ladies and gentlemen. Welcome back to the session 2 of the Second International Conference on Law, Policy, and Political Science. I am Berta Tesma Wulandari, and I will be your moderator for this session. Thank you for joining us. We hope this session will provide valuable insights and meaningful academic exchange in the fields of law, policy, and political science by our great speakers. Before we begin, please allow me to briefly explain the flow of this session. All speakers will deliver their presentation first according to the schedule. After all presentations are complete, we will proceed to a discussion and question and answer session. Participants are kindly requested to save their questions until the discussion session at the end. This will allow us to have a more focused and productive exchange. Thank you for your kind cooperation. Ladies and gentlemen, it is now my pleasure to introduce our speaker for this session. Our first speaker is Dr. Maistra Budiasa. I will share you about the curriculum vitae about Dr. Maistra Budiasa. Dr. Maistra Budiasa is an internationally engaged scholar deeply involved in the intersection of communication, sport, and sociology, demonstrated by his leadership and membership across key global associations. He currently serves as Communication Director of International Association for Communication and Sport, the International Liaison for the Sport Communication Interest Group at International Communication Association, and active membership in International Sociology of Sport Association. He is an assistant professor in the Department of Communication at Universitas 17 Agustus 1945 Jakarta, holding a doctorate and Master of Arts in Media and Cultural Studies from Universitas Gadjah Mada. Dr. Maistra specialized in the critical study of sport communication, cultural studies, and the sociological impact of mediatization on sport events and digital culture. Ladies and gentlemen, we are honored to have him with us today to share insights for the participants of this conference. Without further ado, please welcome Dr. Maistra Budiasa. Doctor, the screen is yours, please.
Okay, thank you very much. Good evening, everyone, and thank you for the invitation to attending this international conference ICONLAPP by Muhammadiyah Bengkulu University Muhammadiyah Bengkulu, and this is very appreciated to me to I can share about the issue media, sport, and climate change. And may I share the okay. Okay, everybody, I'm basically in communication, and I'm now as the Director of Communication International Association for Communication Sport. I will be presentation about the issue media, sport, and climate policy, when this issue is very popular in Indonesia, especially after the flood in Sumatra, Aceh, and South and North Sumatra also West Sumatra. So I will be explanation about how the media and climate policy is closely related with the sport activity. So before I'm starting about this issue, I will be introduce our organization, our association. Our session is the focus scholar, academic, student who focus in communication and sport. And we are closely known the member around 100 scholar from many around the world, but mostly in the United States. And we are established since 2012 and more bigger starting in 2015. Also, we have host conference every year, and next year on March we will have the conference in Dublin, Ireland, who people have the interest with the research or abstract or panel about the communication and sport issue in any kind issue. You can send the abstract and then you can presentation at the conference to the openly network to potential another academic publication. So this is our website, communication and sport, if you wanna more know about our association. And we're starting now about issue media, sport, and climate change. If we talk about sport, it's more than physical activity. Yeah. Where is the view if you wanna looking that? Because sport in the other side, physical activity is not just for health, it's not just for inner body and anything else, but have the social and cultural meaning in the sport itself. So with the issue of sport, we can see how sport can be political, how sport can be economical, how sport can be cultural. For example, if you talk about sport, in Indonesia is a lot of the traditional sport, game of sport. And in the bigger issue is kind of the identity. It's same like cultural. Another way is politic. We know many sport event is useful for the political message in everywhere. Like example in the Indonesia, the sport event is for the issue of the soft diplomacy. In Olympic, also many issue the Olympic related closely with the politic. And the last we can see in the SEA Games 2025 when Cambodia out from the event because the political tension between Thailand. So the sport is more than health discourse or activity discourse. But another issue is can be useful with your sport. And one of them mentioned this is climate change. Sport and climate change is very connected deeply. Why? Because issue, discourse, policy for the climate change is mostly use the sport for the tools of the society can be living. Yeah, like living not just healthy, living for the space, living for the keep secure the environment, sustainability, and etc. So that's why we can see the perspective sport is more than the physical activity with another meaning. And who the support is the issue beside the physical activity. One of the support is the media. We can see in the climate issue, we can see have the green media sport. Green media sport is about how the media capture issue, the green issue like climate, sustainability, and etc. Why? Because the media, one of channel with the popularity in the mass communication, is can be massive, share the issue about how people aware with the environment and everything and etc. And also mega event like Olympiade, World Cup is have the capture a lot from the media. We can see the media when the capture live event in the sport have the revenue is bigger, especially soccer, World Cup, Olympic, and etc. So this is the media is very useful. And also sport as the megaphone for the campaigning about environment. So in the media sport, green media sport is capture this issue. And if we talk about media sport, so basically we talk about what is media sport. I try to find two scholars who definition is media sport. The both scholar Lawrence Wenner and David Rowe, this is one of the leading figure in the communication and sport. Like example, Wenner said, media sport as cultural formation have the mutually constitutive relationship with the sport. Cultural formation is in this meaning is about message, text, representation, discourse, and practice in the content media is closely with the issue sport. So Wenner more so about how sport media and society is the complexity relationship. They are have struggle in its way, but have one common with the negotiation in the issue, especially in sport. Related with the winner, David Rowe is the definition of the media sport is cultural complex because every in the around circle complexity is mutual each other. So experience in sport, media logic, symbolic power, and the narrative is have get the strong message for issue in the sport. So we see with this definition, the media sport, we can conclude is about how the phenomenon social is the explored in the content with the many meaningful in the complexity situation. So how about the sport and climate policy? We back in the sport before we can see how the media and sport is related. Sport and climate policy, actually, we have the more closely and popularity in the COP24 UNFCCC. UNFCCC is United Nations Framework Climate Change Conference every year, and then now is climate change in the 30. So when the conference in 24 is around 6 years ago, UNFCCC is declared, the name is Sport for Climate Action Framework. So UNFCCC is the body under United Nations who conference, who meeting, talk about climate change. And every year until now, it still have the strong debatable between countries to make policy framework on anything else about the climate issue. So the sport is closely put into the climate change issue when the UNFCCC is launching Sport for Climate Action Network. What is this Sport for Climate Action Networks? Is platform for the launching new climate initiative for the global climate policy. So in the Sport Climate Action Framework, the sport issue of sport is the many put in on the platform of the framework. The implementation is every sport event, every sport activities when competitive must be opening or adaptation of the climate policy, like reduce plastic, like building infrastructure is more environment, green, and everything. And this is have the framework in this. And many organizations in the sport like FIFA or Olympic, yeah, and another in Europe is joined with the Sport Climate Action Framework. Next. Yeah, the goal from the framework is promote environment responsibility, engage billions of fans worldwide in the media, and the inspire of the climate action. This is the point goal of the framework. For support this issue, so media is have the main power, the main in the front line to promote this. Yeah, like say in soccer example, yeah, we can see how the media capture fans take it the rubbish after the watching the football. So the media framing that, the issue that, yeah, this is one of the part of the framework um, implementation, one of implementation from the framework goals of the issue climate in the sport issue. Also campaign in the media with the green initiative, with the green issue, in the any content to the billion of the fans of the sport. And what is the climate impact on sport? Why sport have the framework in the climate policy? Because climate change is have the closely impact to the sport activities. For example, extreme heat. Yeah, this is effective in the summer sport like Olympic, or in Indonesia, or in India, or in tropical countries. Example, when you playing sport, anything else in the outdoor, we face to face with the extremely hot heat from the sun. The problem is the athlete must be more have adaptation with this condition, more harder to training because hot in the especially in the morning or a day training. So this is the problem in the sport issue. That's why climate impact on sport in the tropical countries is more closely, not just in tropical countries, but also in the winter countries. Snow, small snowstorm, everything else. Like today, cyclone, when the athlete same, yeah, between extreme heat and the warmer, with the winter, athlete prepare training for the bigger event. And then have the problem with the weather. The weather is now is can be calculated because sometimes raining, sometimes not. Like our parents time ago said January to Augustus to December is always raining. January or June is hot. But today, weather can be predicted. So this is the impact for the climate change. And the last is climate impact in the sport is access the infrastructure sports facilities. Yeah, example today, the situation flood, maybe storm, when the access sport activities destroying about because the weather. So this is the problem from the climate climate effect in the sport. That's why Sport Climate Framework Action Network the build the make it for at least safety the situation in the weather or condition climate change. And what the significance of sport as a platform in the framework? Sport in the platform, the framework of the action network is for communicating ecological crisis, like I said before. With the media, with the another strategic communication inside the organization, international, such as FIFA, such as Olympic, they are make it another issue about how ecological issue is very important to the us. And give education about the environment risks because have the impact to us. And also to give inspiring global audience. So with the three issue in the sport as a platform framework of climate action network is about for the campaigning. The campaigning is not just discourse or content to people aware, but also for the implementation in the action. Like I said before, soccer fans take it the rubbish after watching football and the media capture, and maybe some like Olympic have in the one of the banner sponsor is this area is clear from with the pollution example etc. Yeah, and especially in the green lifestyle and everything else. So include the sport recreation. You know, in everywhere, sport recreation is more bigger. Yeah, like like running, like another sport. Yeah, is popular. The popular sport recreation in the society. This is part of the campaigning for we can be make the lifestyle of the sport to safety the environment. Walking to the office, bike to the office, bicycle to the office. This is the like the movement for part of sport for the safety, the climate. In media, when we can talk sport as the platform in the framework, how the media platform in the framework? Media sport as a platform in the world, in the sport, reach into politic market, popular culture, and nation. It's mean media sport is one when we refer to the Lawrence and the Rowe, media sport with the complexity inside the content, message, relation between society, media as institution, as a sport as the activity, but have the will in the politics example to inspire politician to make like regulation and everything else. In the market, for example, can be like a business in the sport industry. In the sport is must be closely with the issue of the climate and environment. Yeah, like in Indonesia language is industri olahraga ramah lingkungan. Example for that. Yeah. In the popular culture, yeah, like I said before, people in the sport recreation, sport lifestyle. Now is popular is sport culture, yeah, running culture, yeah, pelari culture, and everything else. It's popular culture. Even that is can make discourse for people aware with the environment, and also the nation. We can talk about nation is very popular, yeah, about how the countries have the possession with the environment and everything else. Yeah, and the media sport also potential pro environment issue. Yeah, like I said before. Yeah, the media can be campaign about how to back to work, back to house, walking, and everything else. Campaign about the healthy, that, and also influence in the across field of the social issue, political, culture, and etc. Yeah, like before, the framework is after the sport, after the media, how the Olympic as a platform for the sport. Like I said, Olympic is the mega event. 100 people join the Olympics every 5 years. And media, broadcast media is very a lot. People always attending how the country competition inside the Olympic. People around the world want to looking that. And this Olympic is global stage for the social change. Like I said before, the Olympic is part of the soft diplomacy issue. In anything issue, use Olympic for the promote idea, identity of the country. And also for the political issue and environment. That's why Olympic as one of the platform in the sport framework. So also power media sport have the persuasive for that. Everything with the media can reach audience worldwide, can influence discourse, message, and everything else what I said before. Also, media can be part of the environment action, not just reflected of the issue, but also can be spread the discourse about the environment. Can be messaged to the locally, also globally, with the narrative in the inside the global media sport. Wenner and Rowe, when the definition of this issue is still in the mainstream media in that time, but also can be closely now with the digital, especially in the digital now. It's very, very massive issue to spread this issue. Sport in the climate action have the two issue, naturality and greenwashing, also with the nature. With neutrality, why? Because sport itself can be neutralize everything issue. Even we can use the sport as the political movement, as an identity movement. But in the generally, sport is the neutrality in the all sector than another sector. So for the climate action, sport is very useful for that. And also greenwashing. Greenwashing, actually this is in the critical or economic political issue, such as even the sport event sponsored by bigger industry, but that bigger industry is the part of the destroying of the environment. So why in the climate action spot this not just neutrality and greenwashing, we must be inside this issue, we must be campaign that. Yeah. And the last and the spot is relation of course with the nature, like alam and everything else. The conclusion from this issue, media sport and the climate policy. First, integration all is much essential. Yeah. Sustainability must be embedded across level in the sport and media. Sport and media must be still side by side, going together, not just for support the climate issue, but also must be like the advocacy for the issue who not good for the environment. For example, like the greenwashing, yeah, how bigger industry sponsor of the big event, sport with the not just athlete but also institution, the media also must be together to resist this, to or to make awareness to the issue in the content or narration. Because sport is symbolic of power, yeah, with the issue environment, and can be very mobilized global audience to understand that. Also, in the team, league, venue, media organization, yeah, cannot escape for the ecological impact. Yeah. So in the last, the word is sport must be contribute not only to entertainment, spectacle, people watching, people happy with sport, but to the survival of the community and ecosystem to save our planet, to save our environment, at least for stop climate change is more destroying our society. Thank you very much, and this is my presentation for the watching. Thank you.
Thank you very much for Dr. Budiasa for such an insightful and talk and valuable presentation. Your explanation has provided us with a deeper understanding about topic with the media, sport, and policy, which is highly relevant to current discussions in law, policy, and political science. Thanks, Doc. I would like to make a short conclusion from what the topic from Dr. Budiasa said that about the media and sport and policy and its links to climate change, that sport is not only about the inner body, it's about how it engages politically, economically, and culturally, and give the impact because the sport with power symbolic. So the way we have to know about the green media sport, because sport is platform can be communicate the ecological crisis and campaign for climate change or climate issues, address to environmental risk and inspire global audience. So that's why now Sport for Climate Change Action Framework has been developing to ensure how climate impact to the sport and build the solutions for that. Once more, thank you very much for Dr. Budiasa. We will now proceed to the next presentation. May I kindly invite our next speaker, Dr. Juliana Kurniawati, to take the floor, to take the screens. I would like to share the curriculum vitae about Dr. Juliana Kurniawati.
Dr. Juliana Kurniawati is an Indonesian academic currently serving as a lecturer at Universitas Muhammadiyah Bengkulu and also as the Dean of the Faculty Social and Political Science, specializing on communication studies. She holds a doctoral degree in Cultural and Media Studies from Universitas Gadjah Mada in 2021. Her academic background includes a Master of Science in Communication Studies and a bachelor's degree in Social and Political Sciences from Universitas 11 Maret, as well as a bachelor's degree in Guidance and Counseling Education from IKIP PGRI Madiun. With extensive experience in higher education, she is actively involved in teaching, academic development, and scholarly activities in the field of communication and media studies. Now the time and the floor and the screen is for Dr. Juliana Kurniawati. Please welcome.
Thank you, Miss Berta. Do you hear my voice?
Yes, clearly. I can hear your voice, Doctor. Please.
Okay. Okay, I will share my presentation. Okay. Okay, it's clear, Miss Berta. My presentation is clear.
Yes, your slide has been presenting.
Okay, thank you. Okay, thank you. Okay. Okay, well, thank you, Miss Berta. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah lazim dan kasira kama amar asyhadu alla ilaha illallah wa asyhadu anna muhammadar rasulullah. Alhamdulillah. To the Honorable Dr. Rangga Jayadwanto as a Dean of Law Faculty and our respected audience. Thank you for the time you give for me to present my paper here with the title Reframing Environmental Issues Through Digital Media, a Strategic Approach to Green Policy Mainstreaming During Global Crisis. Okay, I will explain my paper with an introduction. Intersection global crisis, including accelerated climate change, the COVID-19 pandemic, ecosystem degradation, deforestation, biodiversity loss, and transboundary pollution, and then geopolitical instability have placed environmental issues at the forefront of public agendas and international policy. Various scientific reports, including those from the Environmental Panel on Climate Change, or we call IPCC, indicate that the world, particularly in Indonesia, our country, our lovely country, is facing critical tipping point that could threaten the sustainability of social and ecological system. In the context of this complex and multidimensional crisis, the success of policy response depend on not only on scientific evidence or economic consideration, but also on how environmental issues are communicated, interpreted, and negotiated in the public sphere. Okay. In line with this, environmental communication has undergone a significant paradigm shift. Environmental communication can no longer be understood solely as the practice of conveying scientific information in a rational and top-down manner, but rather as a strategic process that serve to shape perception of risks, build policy legitimacy, and mobilize collective support and action. The way an environmental issues is framed, for example, as a threat, an economic opportunity, a moral issues, or a social justice issue, has a direct impact on the level of public acceptance and the accompanying policy accompanying policy dynamic. In our country, in Indonesia, there are many problems and drama, just like this. I will, yeah, I have a screen capture. I think all of you in Indonesia, as an active netizen, known about this. In our country, there are many problems and dramas. I call it dramas related to environmental issues. As we all know, Indonesia is a disaster-prone country. At the end of November 2025, landslide and floods occurred in three regions of Sumatra. There are namely Aceh, North Sumatra, and West Sumatra. However, amid the grief caused by the disaster, there was a drama image building by political actor. Just all of you can see in my slide, which became a hot topic and went viral on various social media platforms. There were content creators who called them as a disaster soap opera star. You can see this in my slide. Zulhas or Bapak Zulkifli Hasan and Farel. The two of us is a political actor in our country, a well-known political actor. And then there was a drama between Ferry Irwandi and Endipat Wijaya. All of you can see here. Ferry Irwandi and Endipat Wijaya. Endipat Wijaya is a council member from the Gerindra Party. Endipat mocked Ferry for his successful fundraising of 10 billion rupiah in 24 hours. According to Endipat, the government should not be outdone in terms of virality. There was also drama involving the region of South Aceh. You can see here, who went to Umrah without the governor's permission after writing the letter stating that he was unable to handle this disaster. Such incident quickly went viral on social media, of course. This actor used social media to gain public attention. One thing that netizens are still concerned about the disaster status. Because until today, the disaster in Sumatra with approximately 1,035 fatalities reported by Detik News, uploaded approximately 20 hours ago, has not been declared as a national disaster. Okay, that's my introduction. And then here I have three problem statement here. Number one, how digital media reframes environmental issues in an era of global crisis. Number two, what communication strategies are used by communication actor, just like government, environmental organization, media, and the public in constructing environmental narrative through digital platform. And number three, how the process of reframing through digital media contributes to green policy mainstreaming in the context of public policy and community participation. Okay, before we discuss about digital reframing, let's first understand the differences between traditional and digital communication. Okay, the communication paradigm shift, yeah, the one about a traditional approach. You can see here that environmental communication historically focused on conveying scientific information in a rational, top-down manner through mainstream media channel. Just like you can see here, television and newspaper like that. And now shift with a digital transformation. Today's approach involves strategic processes that shape risk perception, build policy legitimacy, and mobilize collective action through real-time, interactive, multimodal platform with global reach, just like social media, of course. And digital platform enable faster, more participatory production and negotiation of environmental meaning than traditional media, fundamentally changing how issues are framed and understood. Okay, let's explain one by one. Reframing. I use here reframing argued by Robert Enman. By Robert Enman refers to. Oh, I'm sorry. Okay. By Robert Ehrman refers to the processes of selecting and highlighting certainly aspect of reality to promote problem definition, causal interpretation, moral evaluation, and solution recommendation. I'm sorry. In the context of digital media, reframing process become increasingly complex because it is decentralized, participatory, and influenced by algorithm logic. And environmental issues that were previously constructed predominantly by mainstream media are now collaboratively negotiated by government, environmental organization, media activists, local communities, and ordinary citizen. Just like Ferry Irwandi I mentioned before, who act as both producer and consumer of narrative. We use call that about with the term of prosumers. Okay. This development has direct implication for the process of green policy mainstreaming. Green policy mainstreaming refers to systematic efforts to integrate environmental objective, principle, and instrument such as climate mitigation and adaptation, resources conservation, and the circular economy into the policies and practices of key government sectors including development, energy, transportation, and industry. For this integration to be a successful environment, must shift from being a special policy domain to becoming an integral part of the mainstream policy agenda. Okay, to answer the question raised outright about, I rise above the. I will integrate framing theory by Robert Ehrman, mediation and media ecology by Coldy and Hebb, and then digital environment communication by Koch and Pezzulo, and public policy and social movement perspective. Okay. Now I will explain about understanding digital reframing. Okay. Okay, digital media reframing of environmental issues in an era of global crisis. Number one, digital media encourage a shift in narrative from crisis framing to solution framing. Unlike traditional media approaches that often emphasize disaster and threats, digital platforms increasingly highlight innovation, sustainability, and then practice and collective action. Okay, I'm sorry. This shift reinforces collective efficiency, which is the public belief that collective action can bring about real change, just like Ferry, Irwandi do, and the other what we call the other content creator do. Uh, and the second, the importance of human-centered and emotional-based framing in digital environmental communication through personalized narrative, visualization of affected experiences, and everyday life-based storytelling. Environmental crises are reframed from abstract global phenomena into concentrated issues that are close to the public experiences. This approach increase risk perception and moral evaluation, thereby strengthening the social legitimacy of environmental policies. And number three, digital media facilitates the shift of discourse from the local to the global scale. Local environmental issues such as pollution here in Sumatra and Kalimantan with issues of deforestation or resources conflict are reframed as part of interconnected global crisis through hashtag activism, citizen journalism, and viral content. About hashtag activism, you can see in TikTok like that or Instagram with hashtag pray for Sumatra, just like that, or pray for Bali, pray for the other region who just like Jember. Today I see it in TikTok that Jember have a flood too, just like in Sumatra. Okay. This process reflects the logic of network publics, which allows environmental issues to gain visibility and political pressures across country without relying on mainstream media. Number four, we talk about the role of digital media in democratizing environmental scientific knowledge. Data visualization, infographic, and data-driven narrative simplify complex scientific concepts, thereby increasing public cognitive access to environmental issues. This reframing bridges the gap between scientific knowledge and public discourse, allowing environmental science to become part of a more inclusive policy debate. And number five, digital media transform for the public from passive audience into active producers of environmental discourse. The practice of content production, fact-checking, and digital activism demonstrate a shift toward participatory and dialogical communication. In this context, environmental issues are reframed and collective problems that can be negotiated publicly rather than the exclusive domain of the state or technical expert. And then number six, that digital reframing strengthens accountability framing toward corporation and government. Digital media-based transparency allows the public to challenge greenwashing. Mr. Maestra mentioned this term too about greenwashing. Challenge greenwashing claims and demand accountability for environmental impacts. This reframing shifts environmental issues from the realm of abstract morality to the realm of concentrated political and economical responsibility, which has a direct implication for the legitimacy of policies and institutional actor. Okay, finally, visual politic and integration of new digital technologies strengthen the persuasive power of environmental reframing. Okay, satellite imagery before and end comparison and AI based in simulation increase perception of urgency and future risks. Okay, let's talk about the second problem about communication strategies of communication actor. Okay, about we talk about government and then environmental organization, media and public in constructing environmental narratives through digital platform. Okay. Government communication strategies. I will explain about this. Legitimacy, stability, and technical rationality. I have three about digital transparency, and number two, crisis communication. Number three, bureaucratic framing. Number one, digital transparency as an instrument of policy legitimacy. From a framing perspective, this practice position that the state as a competent, objective, and science-based actor. However, this digital transparency also function as a strategic framing because the selection of data and the way it is visualized determine the narrative of policy success or progress. Okay, the environmental communication literature emphasizes that legitimacy built through data. True data is not entirely neutral, but is contrasted through institutional communication logic that tend to suppress conflict and structure inequality. Number two, we talk about crisis communication and early warning system. In the context of climate crisis and ecological disaster, government have adopted a technology-based risk and crisis economic model. The use of real-time updates, early warning system, risk map, and disaster infographic aims to reduce public uncertainty and increase community preparedness. Just like you can see here about early warning system, the best early warning system in the world, I think, in Japan. Number three, bureaucratic framing and depoliticization of crisis. Another okay. Bureaucratic framing in which environmental issues are framed as part of sustainable development agenda, which is like SDGs commitment or international obligation. This framing position environmental crisis as long-term managerial issues rather than political conflict or moral crisis. Okay, this approach is effective in maintaining policy stability, but relatively weak in encouraging public mobilization. In framing theory, this approach reflects diagnostic framing with minimal attribution of responsibility and low motivational framing. Okay. Next, about environmental organization strategies. I have three points here about emotional and moral framing as key strategy. Number two, digital campaign and logic of connective action. Number three, visual storytelling and politics of representation. Okay, Number one, unlike the government, environmental organization consistently rely on emotional and moral framing to build environmental narrative in the digital space. Narrative of the suffering of affected communities, ecosystem damage, and species extinction serve to humanize the environmental crisis and arouse public empathy. You can see this in digital media or social media. Okay, and the literature shows that emotion such as moral outrage, empathy, and a sense of justice are key element in driving public engagement and political pressure on policy maker. Okay, in this context, environmental framing shift from technical issues to issues of ethic and ecological justice. Okay. Number two, digital campaign and the logic of connective action. Okay, the study also shows that environmental organization utilize digital media to build connective action, which is mobilization based on loose networks without rigid hierarchy, what we call say hierarchical structure. Okay. Uh, I hear you use about the hashtag based campaign, just like I mentioned before. Online petition, I think all of you know about online petition, and virtual action enable cross-border and cross-generational engagement, as seen in youth-led global climate movement. Okay, number three, visual storytelling and politics in representation. Visual storytelling is dominant strategy of environmental organization in the digital space. Images and videos of environmental damage serve as symbolic representation that bind fact, emotion, and moral demand into a single visual narrative. In the framework of visual politics, visualization does not merely describe reality, but shapes the way of public assesses their urgency and responsibility for the environmental crisis. Here, I give uh, uh, I give you the visual storytelling that I screenshot from the TikTok. You can see here, ditebang. Okay, this is green, what we can say, forest, green forest, and this, the tree is gone, and this Sumatra Utara, this float. Okay, select a visual storytelling. This is an example from visual storytelling. Okay, next, we will discuss about media communication strategies, visibility, conflict, and credibility. Okay, but the media strategies we have here, agenda setting, then journalism, and conflict framing. About public participation, we have citizen journalism, digital action, and experiential framing. Okay, about agenda setting, mass media and digital native media act as regulator of environmental issue visibility through agenda setting mechanism, of course. However, in the digital era, issue selection is increasingly influenced by algorithmic logic, virality, and audience engagement metric. As a result, extreme disaster and policy conflict receive more attention than long-term structural environmental issues. Number two, data journalism as a credibility strategy. The use of data journalism and environmental visualization has become a media strategy to increase credibility and strengthen evidence-based claims. Presenting trend in global temperature, deforestation, and air pollution help the public understand and about environmental crisis in systemic and temporal manner. Okay, and number three, conflict framing and discourse polarization. The media also tend to use conflict framing, especially in environmental issues involving powerful actors such as the state of corporation. Although effective in raising public awareness, conflict framing has the potential to oversimplify the complexity of policies and deepen polarization of opinion. Okay. About public participation, citizen journalism, and the disruption of information authority. The result of we can show that the digital public is increasingly playing as role as information producers through the practice of citizen journalism, citizen documentation of flood, forest fires and pollution often become a primary source that force the media and government to fast respond. Okay. Number two, deliberative participation and digital action. Public participation is also reflected in online discussion, online petition, and environmental crowdfunding. Crowdfunding, just like I mentioned before. This practice expand the policy arena from formal institutional space to digital discursive space, strengthening the deliberative dimension of environmental communication. Number three, experiential framing and psychological proximity. Personal experiences-based narrative have proven to have high resonance because they shorten the psychological distance between global crisis and everyday life. Okay. The direct experiences of affected citizens shape stronger public awareness of risk and solidarity, of course. Overall of these so the environmental communication strategies on digital platform are an arena for what? Arena for contestation between technocratic rationality, emotional morality, media logic, and public experiences. Digital reframing not only shapes perception but also determines policy legitimacy, participation pattern, and the direction of social mobilization in the face of global environmental crisis. Okay, you can see here. This is Ferry Irwandi in YouTube. This is Lindungi Hutan in Instagram. Number three, Pemuda Lingkungan in Instagram too. I'm sorry, Lindungi Hutan in TikTok, I think. Okay. Okay, we talk about a relevant framing mechanism for mainstreaming policy. Number one, increasing issues salience, of course. If the issues is not salient, so people become not aware about that. Okay. increasing issues salience, digital agenda setting. Through virality, trending topics and amplification by influencer, or organization, digital media increase the visibility of environmental issues so that they enter the public and political agenda. When an issue becomes top of mind, a policymaker experiences political pressure to respond. An important prerequisite for moving the issue onto the formal agenda. Number two, sorry, number two, changing the frame of cause and solution, diagnostic, prognostic framing. Digital reframing influences how problems are described. Who is responsibility? Who is responsible? Individual, corporation, or the state? Versus corporation versus the state or versus individual, and that solution are considered viable technology, regulation, economic incentives, or collective action. A frame that emphasizes economic cost, public health, and then innovation opportunities tend to be more successful in placing green policies on the agenda of other section. Okay, thereby facilitating mainstreaming. Number three, mobilizing new advocacy coalition, and networks public. Digital perform bridges diverse actor, just like NGOs, scientists, green companies, local communities, and the public to form coalition that drive policy agendas. This coalition play the role of policy entrepreneurs who size movement with the policy windows is open to include green opinion in policy package. And then strengthening evidence and legitimacy through public data and citizen science. Low-cost sensors, interactive maps, and crowdsourced database provide local empirical evidence that can be used for policy argument. Evidence of air pollution to strengthen emission regulation. The availability of public data makes it easier for policymakers to formulate evidence-based intervention and increase the acceptability of the green policy. The green policies. Okay, number 5, transforming risk perception and cost. When digital media present narrative linking environmental risk to public health, household economics, or critical infrastructure, the public and policymakers tend to view the integration of green policies as a pragmatic necessity rather than merely of normative choice. This kind of framing open up space for more ambitious regulatory and budgetary policies. And number 6, supporting accountability and enforcement practices. The virality, again about the virality of evidence of environmental violation in Indonesia is just like illegal logging, industrial pollution, or greenwashing trigger political and public reaction that pressure policy implementation and law enforcement. Digital media function as a non-state oversight mechanism and accelerate bureaucratic response. Number 7, creating social, creating social norm and political legitimacy. Digital narratives that highlight sustainable practice, just like for example, urban cycling, circular consumption, they change social norms so that policies supporting these behavior gain massive support. When norm change, integrating green issues into everyday policies become more acceptable. Okay. Yeah. We discuss about from public attention to mainstream policy. Here about I'll explain about the presence of trigger. The presence of trigger event. The presence of trigger event. They are example disaster, investigate TIFF expose or viral campaign generates public attention. And number two, digital amplification. Number three, coalition formation. Number four, policy window open. Policy window opening. Number five, adoption and mainstreaming. Number six, enforcement and normalization. Yeah, from public attention to mainstream policy. Okay, we talk about challenges and okay, I will discuss about before this participation via a petition. Petition online, online consultation and deliberating platform allows the public to contribute argument, data, and oversight that make policies more responsive and legitimate. Okay, so the viral and online petition or e-petition can change or make policies more responsive and legitimate. Of course. Okay, and we now talk about challenges and limitation. Here, this information, okay, disinformation and counterframing about anti-regulation actor frame economic cost. Okay, sorry. Cost to cost to throat green policies, creating competing narratives that cause public understanding. Okay, number two, the challenges and limitation about polarization and echo chamber. Okay, about digital fragmentation means narrative only reach relevant audience. Of course, if we everyday see about the sport and the our algorithm is about sport, just like Dr. Mistra. I see. Okay, and then about power asymmetry, resources and access differences enable large corporation to dominate, framing overwhelming grassroots environmental voice, and then institutional barriers, bureaucratic capacity limit. First, fiscal conflict and lobbying influences can hinder policy adoption despite high public pressure. Okay, this is my last and my summary. Okay. The repositioning of digital media from a communication channel to a discursive and political infrastructure in environmental governance by integrating framing, mediatization, and network public theories. In this article or in my presentation, expand that understanding of green policy mainstreaming as a communicative process that is publicly negotiated rather than merely an administrative procedures. My paper shows that digital reframing function not only as communication strategy, but also as a critical governance mechanism that shapes how environmental issues are translated into mainstream policy dominant. Okay, I think that's all my presentation, Miss Berta. Thank you for the time for me. Naseminallah wa fatum kari, babasiril mu'minin, wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Dr. Juliana Kurniawati, for such an insightful and valuable presentation. Dr. Juliana Kurniawati talk about the topic reframing environmental issue through digital media. Dr. Juliana Kurniawati has been presenting many issues in Indonesia during Sumatran floods and landslides. Very great knowledge for us to discuss about that topic. So there are many postures within our government actors, even media influencer. What I conclude from Dr. Juliana Kurniawati's presentation is that reframing environmental through digital media platforms is very important because it's enable faster information, product us new discussing issues, and provoke community and society through massive public digital media. And it also promotes environmental scientific knowledge and to facilitates to inform the discourse such a disaster from local to global scale. Once more, thank you very much for Dr. Juliana Kurniawati. Ladies and gentlemen, we will now move to the next presentation. May I kindly invite our next speaker to join us. Please welcome Deborah Jane Martyr. Still waiting for her? Still waiting for Miss Deborah Jane Martyr. I would like to share you about a little bit about our speakers this session. Deborah Jane Martyr, a British researcher and conservation practitioner, is currently an expert member of the International Union for Conservation of Nature, or IUCN, an international body comprising governments, civil society organizations, and conservationists working together to advance sustainable development and create a just world that values and conserves nature. Despite being British, she is perhaps more familiar with the forests of Sumatra than most Indonesian researchers. In 1995, she conducted research in Kerinci Seblat National Park. This research was conducted to validate the existence of large primates locally known as uhang pandak or urang pandek in Bahasa. From 2000 to 2015, she served as manager of the Sumatran Tiger Protection and Conservation Program in Kerinci Seblat National Park. This program is a collaboration between Fauna and Flora International and Kerinci Seblat National Park to ensure the conservation of the Sumatran tiger. She currently serves as an advisor to the program and is responsible for providing input to ensure local knowledge and local priorities are guided by science in developing and implementing the Sumatran Tiger Conservation Program. For her work and real contribution in the field of conservation, in 2015, she was awarded Member of the Order of the British Empire by Her Majesty Queen Elizabeth II for services to the conservation of the Sumatran tiger. So, we proudly present you Miss Deborah Jane Martyr. Good afternoon, Miss. Are you here with us? Okay, just waiting for Miss Deborah Jane Martyr. Okay, we just get the information that Miss Deborah Jane Martyr still in progress to rejoin us in the Zoom session. So, Miss Deborah Jane Martyr is really get the sincere appreciate because for her work and real contribution in the field of conservation in Kerinci Seblat National Park to save our fauna and flora as a Sumatran Tiger Protection and Conservation Program in Kerinci Seblat National Park.
since 2000 to 2015. And she was also conducted the research to validate the existence of our late primates, locally known as uhang panda or orang pendek in Bahasa. So she is really good that people outside Indonesia, as being British, she is more familiar with the forests of our Sumatra Island than maybe most Indonesian people as well. Very great. One more, I would like to recheck, is there any information for Miss Deborah Jan Martyr for joining us? Hello, Miss Deborah. Good afternoon from Bengkulu, Indonesia. Selamat siang. Can you hear my voice, please?
Good morning.
Okay, good morning too, and good afternoon from Indonesia right now.
It's 7:30 in England, and the time is 7:30, and the temperature is 1 Celsius.
Okay, very great. Okay, Miss Deborah, I already shared the participants about your great curriculum vitae. So this is now your presentation. So the screen is yours, please.
Yes, I would. My presentation is on a tablet that is broken. So I am here on. I am here. Can you have, I think, got my presentation with you?
Yes.
So if you can share it on your screen to your colleagues, and then we can talk through it. It's not going to be like the very detailed and interesting presentation I've just been listening to, which raised some very interesting facts and points. And I'd rather we talked this through on the basis of a person now in England listening with huge interest to the future of conservation science in Bengkulu and Sumatra more widely. Can you hear me?
Excuse me, Miss Deborah, can you
Yes.
see the slide on our presentation?
Yes, I can. Yes, I can.
Yes, please.
And yeah, and as you can see, it's dark outside. And so I'm sorry I'm not using the backdrop for this conference. I apologize. Yeah, as we say in England, these things happen. Conservation, even especially technical, is full of challenges as well. Okay, fine. I think you've already been discussing habitat loss and forest loss in this meeting. Am I right?
Hello, Miss Deborah.
Yes.
Yeah.
Can you stay on audio as well?
Yes, it's very clear here. Your audio,
Okay,
please. Mhm.
Boleh kita gabung bersama di dalam presentasi ini?
Yeah, there is no problem here. So we can
I
hear your
talked to
voice clearly.
you. I talked to you using the slides. I did yesterday and the day before yesterday, and we talk it through. We talk this through as my presentation. It will be easier because I haven't been very well, and now my tablet has broken. My new tablet. Mama. Boleh, begitu.
Okay.
Okay, kalau kita kembali ke slide pertama sebentar. Okay, yeah, first of all, obviously, we have the issue of habitat loss, of forest loss, not just in Indonesia. If you look at Malaysia, Malaysia is actually more significant than in Indonesia, than in Sumatra. In Nepal and India, they have reduced habitat loss, but it would appear that they are increasingly being impacted by climate change due to, particularly in India with drought, and habitat is being lost in Nepal, again, due to global warming and climate change. In Bengkulu, mainly we have lost lowland forest, as we all know, but tigers are much more flexible in tropical rainforest than people originally thought. When I first started working in the field in Indonesia, they said there were 70 tigers in Kerinci Seblat landscape, because they said tigers very rarely above 500 meter above sea level. So good science and field work, not just in Kerinci, but across Sumatra, has delivered hugely important data on tiger distribution and landscape use. But we still need to understand, especially now that we have a changing climate and due to forest loss, habitat loss, and particularly habitat fragmentation, is a driver of human tiger conflict. And there's a paper that I can send the details to you all later if you do not know this paper, which was looking at population viability of tigers in Sumatra. And so as we lose habitat, landscapes become fragmented, and we have populations which are no longer viable. Kerinci is recognized as one of the areas where tigers should be viable in the long term, providing the habitat and the landscape isn't fragmented. And we have, of course, already lost those forests, that forest connection down in the far south, leading on down to Bukit Barisan, Selatan, and the forests in between. Prey base, I think, I don't know if anyone here in this meeting has been working on it, but the loss of a huge population fall in wild boar, babi hutan, and babi gunung was caused massive problems in terms of human-tiger conflict, particularly in Bengkulu. But we also have the problem of prey-based loss through poaching of deer, muncak, kijang, and that one, particularly in some areas of the park, some areas where you have a cultural affinity with hunting, is something we have to watch very carefully. Rusa sambar, that's Rusa unicolor. They are at a very low density now in Kerinci Seblat and other landscapes of Sumatra, and it's a cause for concern. Then, of course, we have the illegal wildlife trade and poaching of tigers themselves. That does appear to have reduced a lot in recent years. I think in part due to good, stronger law enforcement, greater awareness. And we have the good bit that for young people, a tiger skin is a sign of an old-fashioned person, not just in Indonesia. It's becoming very unfashionable, I think, to trade and buy tiger products. Although I think in China and Vietnam, there is still demand for tiger products for medicinal purposes. But the key point for tiger conservation, all these challenges are interlinked. So we have a human-tiger conflict ending up in a poaching incident, which ends up with illegal wildlife trade, that the incident at the beginning was connected with habitat fragmentation or habitat loss. And so, like so many conservation challenges, we can only address it if it's integrated and we're taking all these things into account. Even if we concentrate on one area, all these are other factors that influence and should influence our work. Next, I think. Okay. This really doesn't apply to any of you, I think, as conservationists. If you're looking to work to conduct research in Bengkulu, because I'm Bengkulu. But one of the great failings in conservation is a tendency by big international and some national NGOs, academics, institutions, is to look at a problem or to develop an approach to a project based on lack of knowledge of the people, of the culture, and the factors, local factors that need to be looked at. So my experience is, local. We think local. We draw on local knowledge. We respect and learn from local people. That includes forest rangers. It includes Padukun. It includes everybody. And we learn from them and we hear them. And we're able to start to develop a project that uses sound science, good conservation measures, but understands some of the local factors and the local pressures that are cause of a problem. As I said before, threats are very often interlinked, and we can't necessarily address just one. But we address it everywhere, even within one kabupaten, even within one kecamatan. There will be line lubuk, but we have to work on a line lubuk, line ikan, because the problem is a little bit different. The overall challenge is the same. The overall goal is the same. But the best phrase ever in Indonesian language, line lubuk, line ikan, line padang, line belalang. Be flexible, use sound science, but recognize and identify the local challenges and draw on local knowledge to identify solutions. Okay. I think in this one, it comes down to communications and trust, because if we're going to have human-tiger conflict, it's a huge threat to human-tiger coexistence. I think it's slightly different. There's many animals will come into conflict, or we will come into conflict with them, but a tiger can kill a person, it can destroy a livelihood, maybe not as effectively as an elephant. And so how we can learn to identify areas where there is a problem, how we can work with communities so they report quickly that there is a problem. When I started work in Kerinci Seblat, when we started the Tiger program, even though I'd been in Kerinci for a long time, we very quickly realized that human-tiger conflict was a much larger problem than appreciated by anybody, because villagers were not reporting conflict, minor conflicts, because they didn't know that somebody would respond. The national park in KSDR thought conflict was very rare because nobody was reporting it. And that is, I think perhaps, yes, that is one of, it applies to so many problems, so many conservation challenges. How we get people to report and recognize a problem so that we can address and collaborate to build a better coexistence with that species. I think one priority area for us all to look at is how we are able to find some form, get the government perhaps to address how we can secure some form of insurance, not compensation, insurance schemes for villages for crop loss and for livestock loss from conflict where it's not their fault. I think that would be helpful in terms of reducing financial impacts on people, but it should, yeah, it is an area that we could all explore. I think it would make sense for conservation, and it would reduce bad feeling if somebody loses livestock through no fault of their own. When we started work in Kerinci in 2000 on the Tiger Project, we knew that there was tiger poaching and we knew that there was tiger trade, but we did not know how serious that problem was. In the late 90s, on buses, I had been offered as a boule, would you like to buy a tiger skin? Then in the forest, I had met tiger snares. These were two problems that I had reported to the national park or to KSDR. Nothing happened, and that was one reason we set up the Tiger Project in Kerinci. I say we because you can't do conservation as one person. It's a part of a team. But it was much more serious than we had appreciated. And one reason was it hadn't been recognized. Poaching, whether it's a tiger or a rare songbird, it all comes down to money and how we can make the risk of being detected and some form of action being taken, even if it's just your deer snare being destroyed. How can we make the risk of detection outweigh the reward you expect? If it's you lose your deer snares, you've spent 2 days setting snares for Risa Sambar, you spent 4 days, 5 days in the forest finding the right place to set snares for a tiger and they're destroyed. That means you've lost money and time on logistic that you could have been elsewhere. If you do catch that tiger, you try to sell it and you get arrested, it becomes even worse. there's been a lot of good work being done recently by Linkar in Bengkulu. So while we've got patrols in the forest and investigations into illegal wildlife trade, we've got youth working with Linkar, have been working with religious leaders to highlight that under Islam, it is, yeah, nature should be looked after and protected under Islam as well. It's our duty. So once again, on poaching and the illegal trade, it's recognizing that there is a problem and asking. Good conservation is like good science. It's always about asking questions. And if there's no answers, ask more questions. And the fewer answers, the more interesting the questions become. So, okay. Over the last 15 years, 10 to 15 years, I'm very proud of the work being done by so many people, where we have seen poaching and illegal wildlife trade threats to tiger reducing. It now might take 30 or 40 days patrolling in the forest to find a snare, where in 2010 you might only do 3 or 4 days or 5 days to find a tiger snare, an active snare. In the last 2 years, I think more than 100 days in the forest per snare, per tiger snare. So, yeah, the cost of poaching now outweighs the reward, or is outweighing the reward. And we're seeing tiger populations relatively stable, perhaps with a greater impact from the risk of conflict and habitat loss. But we have to maintain that, always ask questions, always look for problems in terms of conserving wild tigers. We need always to continue to work together to build those partnerships, local, national, international, with religious leaders, with academia, with farmers, with forestry. One person can't do everything, as you all know, as we all know, but we can work as a team and strengthen each other's work. I think, coming back to what I said earlier, is always remembering line lubuk, line ikan. There's going to be different problems in different locations, different community approaches and outlooks, different priorities by local government and national government institutions, and how we can build a broad framework which supports actions at a forest and wildlife conservation level, not just for the next year or two, but into the future. And yes, there remains so much more to be done. I am very concerned by the rise in illegal wildlife trade online, and not tigers here, this in particular, the exotic pet trade. I think over the last 2 or 3 weeks, there have been a number of several more siamang and unca seizures in Thailand, sorry, Malaysia and in India, with primates from Indonesia and from Malaysia being shipped to India for the international, for illegal pet trade. In Indonesia, I've been looking at the trade online in Kuching Hutan. As you may know, they are now separate. They're no longer Prunalaris bengalensis. They've been separated from the mainland leopard cats, and so we have 2 leopard cat species in Indonesia. And I found groups on Facebook, just on Facebook, 160,000 people interested in owning, buying, selling, breeding leopard cats for pet trade. The same applies to otters. So the illegal wildlife trade and hunting may be changing, is now changing. It's going online, and there seems to be a shift to trading pets, smaller animals and birds, which are also rare and part of our rich heritage in Sumatra, and we have to be aware of that. I think for all of us, we've had, in my case at least, I know that we've had immense support from so many government agencies, national and local, but how we can get them to work sometimes in some areas, on some aspects, how to help them work together more efficiently with less bureaucracy, but that's, I don't know. And then we have what happened last month, which is, climate change. But we also last month saw the beginning of action to address the massive deforestation in Bentang Sebelat, in Bengkulu Utara and Muka Muka, in 2 logging concessions. So the challenges are there. They're changing and will always change. We have to be flexible, alert, looking for trouble. If you're a good conservationist, you're always looking for trouble, because there's always going to be a challenge out there that you haven't recognized or colleagues haven't recognized. And yes, busy. Conservation translates as busy. Thank you. Salam Lestari.
Thank you very much, Ms. Deborah Jan Martyr, for your great presentations and for your valuable experience sharing to us today. So from what you said before about the topic, the conservation for Sumatran tiger, that it begins on many issues, such as habitat loss, habitat fragmentation, human-tiger conflict, illegal trade, and climate change. So those are issues needs action in order to reduce low population for Sumatran tiger and to keep their existence. So Ms. Deborah Jan Martyr makes some approaches like identify local conservation priorities and draw on local knowledge to build locally relevant tiger conservation strategies, and make collaboration and integration approach, including partnering with local and national civil society, government, and key community leaders, and to support informed advocacy by local NGOs around the Kerinci Sebelat landscape that has twice played a key role in defeating proposals for roads through the national park and supported actions to address numerous other conservation challenges. And for those all, we are very proud to Ms. Deborah Jan Martyr for your effort to make a conserve for our Sumatran tiger. Terima kasih. Okay, ladies and gentlemen, we have now reached the discussion and question and answer session. Participants are welcome to ask questions or share comments related to the presentations. Please mention your name and affiliation before asking your question, or you can also write your questions on the chat box. We kindly ask that each question be concise to allow more participants to engage in the discussions. Now we invite all participants and it's open for questions, please. So, Please, for all participants, students, and our guests here, to share your great questions for our speakers, both for Dr. Maestra Budiasa or Dr. Juliana Kurniawati or Miss Deborah Jan Martyr. But I have one questions on the chat box. This is come from Mr. Fabi Iqbal. He is having one question for Dr. Maestra Budiasa. Hello, Doc. Are you still here with us?
Yes, I'm still here.
Yeah. Is there one question for you? To what extent is green media sport capable of changing the ecological behavior of audiences? And whether sustainability narratives in sport media more often function as environmental education or simply as a green strategy? Please, maybe you can answer that question first, Doctor, please.
Okay, thank you for the question.
Yeah.
From from the Febi, yeah? Yes, he asked about the green media support to support the issue, the climate crisis. So yeah, the greening media support, if we more understanding is have the six, I think have the six overlapping or various actor in interest agency, such as I said before, with the definition by media sport by Roy and Lawrence Wen is about how the complexity. So the six overlapping complexity is about between the sport team club association, between athlete, event, and then also stadium, environment climate makers, and also uh, what the meaning of the fans. So this them is all part of the complexity in the green media sport. So I think if we are mix the overlapping between the that when I said before is about the stadium, mega event, apparel equipment, infrastructure. It could be green media sport. It will be helpful to promote about the climate issue, the climate change issue. And how about the how this is just strategy or this is this implementation? I think today we can show the media is a process to be implementation how the people aware about the climate issue, especially in the sport. Like I said before in the presentation, it's about how the uh, media focus with the content. The content is not just narration, but also in the sport by the stadium banner example to issue about the climate environment aware, such as you don't get the rubbish in the place in other place, like example like that, and then also in the inside the stadium you can have the box of the rubbish you can choose when yeah like the regulation like they see. So I think the green media spot is very effective to be promote the climate change issue. But the problem is about the complexity because inside the complexity is the have the political economy issue, have the uh, greenwashing that he said before, they have the greenwashing by the big industry and etc. So in the other part, mostly is effectively, but in the another part, we face to face with the political, economic, and industrial issue. But today about the issue in the media sport campaign, I think it's not just strategy, but also now going to the implementation problem. So that's why I have the sport climate action framework. This is from the bigger uh, uh, regulation to umbrella this issue. Yeah, I think like that.
Okay, that's all the answer, Doug?
Yes, yes, that's all. Thank you.
Okay, very great explanation and very great answer from Dr. Budiasa. Thank you very much for your answer, the question. Now we move to other participants. We have here one of our students. May I call her? Revalia Seplina, hello. Could you please open your camera, please? Yeah, Miss Revalia Seplina will give a question. Maybe which speakers do you want to giving the question, please? Okay, if you have any trouble or issue on your Zoom, maybe you can also write your question on the chat below, on the chat box. Okay. So this is the question from Miss Revalia Saplina, still for Dr. Maestra. And then we will move to other speakers, yeah? Please wait. How should sports organizations strategically communicate policy decisions to balance public accountability, athlete welfare, and commercial interest in the digital media era? So that's the question, Doug. Would you like to answer this question right now?
Yeah, okay. I will
Okay.
try to. I will ask. Yeah.
Yeah.
She is Revalia, yeah. You asked about to make strategic communication to the public for the trust with the organization, especially in sport, because we know during this time, sport organization have quote unquote is perspective negatively. And today, if we are talking this is not specific in the issue about climate, yeah, but this is specific about accountability and the athlete and the commercial interest in the digital media. Yeah, we can see how the now sport organization try to be adaptive with the any kind issue or growing up people or society in the digital era. That's why now you can see sport organization not just use the television or the mainstream media, they are use the TikTok, they are use YouTube, they are use Instagram to promote anything else, to campaign anything else about sport, and also to make the public accountability, to make public trust with the issue with the sport, especially in the sport. So they are make like content, or they are invite the influencer. They are use influencer to make content to anything else. So this is for the make trust public accountability to the public. Yeah. And also with the athlete welfare, you can see today in the SEA Games example, in the digital media now is many content about how athlete is very hard to training to get in the SEA Games today we get number 2 in the medals. So how people struggle, athletes struggle to get medals, to get to the SEA Games and anything else, and in otherwise have the um, reward from the government to the athlete to get the medals with the 1 billion etc. And this is this narration is also have to not just in the mainstream but also in the digital media, social media. So in the commercial interest, yeah, you can see the digital media know a lot of the narration content, especially in the sport recreation, like I said before in the presentation, how more closely with the commercial issue. Yeah, I think that's this hopefully can be answer the question from the referee.
Thank you, Doctor, for the answer. I hope that students or participants get the point from what Dr. Maestra Budiasa said for us. Next, we move to other questions from chat box. It comes from Miss Amalia Puspitasari from Universitas Muhammadiyah Bengkulu. Let me introduce myself. My name is Amalia, a student at the Faculty of Law, Universitas Muhammadiyah Bengkulu. I have two questions and would like to ask Miss Deborah to respond these questions. And the first question is, why is it important for us to conserve Sumatran tigers? And the second one, as the younger generation, what must we do to protect the Sumatran tiger from the threat of extinction? Please, Mrs. Deborah, time is yours.
Aku dia nak ngece.
Oh, yeah, okay. That's okay. Yeah.
Sudah tua, masih pagi. Amalia, I think why it's important for us to conserve Sumatran tiger, because they're a flagship, but they're also a warning sign for the forest and for our climate and our planet. Tigers are an obligate carnivore. They depend on prey species in sufficient abundance that they can hunt and take prey, but not deplete those prey. Those prey species in tropical rainforest in Sumatra depend on the forest. And as what happened last month in Sumatra Barat, Sumatra Utara, and Aceh, we see what happens when the forest is damaged in a period, and we have, as a consequence of climate change, which is related in part to forest loss. We had 1,000 people, more than 1,000 people died, and hundreds of thousands impacted. So let's be selfish here. Let's conserve Sumatran tiger for our future well-being and our people's future well-being, because we have to protect our forests to protect us and our watersheds. As of the younger generation, what must we do to protect Sumatran tiger? I think it depends. In 20 years ago, 30 years ago, one would say things like, don't buy a tiger claw because you think it's clever and pretty to have, or a bit of tiger skin, or I think what we must do to protect Sumatran tiger from the threat of extinction is what we've been talking about hearing in this meeting, which is try to be responsible with what we do in our daily life, what we do when we shop and purchase and travel. And as I say, we use tigers as a flagship for our forests, as a cultural icon, but also as a traffic indicator for the health of our ecosystem. Is that okay?
Okay, yeah. Terima kasih, Miss Deborah, for the answer. Very great explanation that we have to conserve our Sumatran tiger because the population of that animal very low right now, since many illegal trade and also human tiger conflict, and so also that the climate change make this more struggle for us in Indonesia to keep our tiger Sumatran. Thank you. Next, we move to other questions. Oh, it's still for Miss Deborah. It comes from Fabi Iqbal. Hello, Fabi Iqbal. Since you raised your hand,
Fabi. Yo.
yeah, maybe you can also communicate live to Miss Deborah, please.
Hello, Assalamualaikum.
Kabar kayo?
Formation. I introduce myself. My name is Febi Iqbal. I'm from Bengkulu. My question is, how can communication, policy, and local cultural knowledge be integrated to promote sustainable human tiger coexistence without sacrificing entire community livelihoods or wildlife conservation? Thank you.
Well, Fabi, that is one of the biggest questions. That is such a good question. And Fabi, I can't answer that without saying lain lubuk lain ikan. Well, where do you come from? Dari mana? From where? Fabi, dari mana in Bengkulu?
I'm from University of Muhammadiyah Bengkulu.
Where do you live? Your family? Asal mana?
I'm from South Sumatra.
Yeah. Okay. And in your home area, what is the major crop? The villages. Yeah, we come back to line lubuk line ikan. How we can be responsible in our farming practice, how we can help villages to improve their economy, but without sacrificing the forest. And I think every village, every community, it's going to be a little bit different. I think, like I say, I think we have to integrate our knowledge of that community. We have to find the right people to communicate with, which might be village leader, it might be orang adat. We have to build a strategy and a policy at community and wider level. But line lubuk line ikan, so that villagers, the people, our communities, we can't say, you must not do this, you must not do that. You don't. When they see people on television with a motorbike, they see people on television with equipment, they go past, they see advertisements, they see people's lifestyles improving. We can't say, your economy must not go forward just because, line lubuk line ikan, we have to work together to find ways our communities can advance, that they have a livelihood that gets better, but without sacrificing our forest and our wildlife. And I'm sorry that's not answering your question, but I think is agreeing with your question that we must communicate policy and cultural knowledge to do what you need to do, conserve and advance community interest.
Very great. Thank you, Ms. Deborah, for your answer this question about the how to manage and how to, against the conflict between human and tiger and Sumatran island. Thank you.
Honey, I think we have to minimize a conflict of interest.
Yes.
We have the interest of conservation and the interest of economy. And how do we find a way that this is not a conflict of interest, but supporting both interests?
Mhm. I agree with you. Thank you very much. And the last question comes from Salsa Nabila from Universitas Muhammadiyah Bengkulu. This question comes to Mrs. Juliana, to Dr. Juliana. Hello, Doc. Are you still here with us?
Yep, I'm
Okay.
here.
Yeah. From the question in the chat box that Salsa Nabila Putri want to ask you about what from your presentation that has been delivered, that how does the reframing of environmental issues through digital media concretely contribute to the legitimacy and mainstreaming of green policies amid multi-dimensional global crisis? Please, the screen is yours, Dr. Juliana.
Okay, thank you, Mrs. Berta, and thank you for Salsa for your nice question, and I think a good question. Okay, I'll try to explain. I'll try to answer your question. Reframing environmental issues through digital media contributes to the legitimacy and mainstreaming of green policies by translating abstract ecological risks into relatable social, into economic and moral narratives that resonate with diverse publics. Through strategic storytelling, like I explained before, through data visualization and use influencer mediated communication, digital platform enhance policy transparency, normalize green discourse, and then link environmental action to everyday concerns such as health, jobs, and security. This process foster public trust, broadens stakeholders' engagement, and generates social consensus, enabling green policy to be perceived not as elite-driven agendas, but as necessary, just like collective responses to multidimensional global crisis. So reframing environmental issue through digital media, I think is important to today for our government, to promote, to make us, to make netizen, to make Gen Z, or to make the politic actor realize that our environment is broken now, and we have to make one one movement to Gen Z, just like maybe make some movement, go green, like that, go green, and one over satu tanam satu pohon, nah, like that. But promote in social media, and I think that's all my answer to salsa. Thank you.
Thank you, Dr. Juliana, for your great answer for our student, Salsa. And I think that's all the question from our participants for this sessions. Ladies and gentlemen, now we proceed to the next agenda, is the closing session. Thank you for the insightful questions and engaging discussion between us. On behalf of the organizing committee, I would like to express our sincere appreciation to all speakers, Dr. Meisha Budiasa, Dr. Juliana Kurniawati, and the special one, Ms. Deborah Jan Martyr, and the participants for their valuable contributions. This concludes session two of the second International Conference on Law, Policy and Political Science, and will be continuing to oral presentation. Thank you very much and enjoy the rest of the conference. Goodbye.
Thank you.
Cek. Cek.
Belum
Belum.
unmute.
Masih unmute.
Cek. Bukain.
Udah sini.
Dia boleh menampilkan video.
Tampilkan video.
Videonya positif.
Cek. Mas Olehan bisa langsung, Mas?
Oke. Thank you.
Silakan.
Thank you. Oke. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everybody. Distinguished speaker, ladies and gentlemen. And now we continue our second international conference on law, politics, and policy, ICONLAPP 2025. We continue for the third session, oral presentation. In this session, there are two ways in presentation. Some of speaker present by video, and some of them present in this session. So I'm Solehan from Law Faculty of Universitas Muhammadiyah Bengkulu. I will guide as moderator here. Before we begin this session, there are many important inform you about the rules of this session. Please keep your microphone mute during the presentation session, and then this presentation and this seminar is being recorded for the documentary purpose. Okay, ladies and gentlemen, let me start for the first speaker from this session. I call Mrs. Sajida Humaira. Are you here? Mrs. Sajida? Where are you, Mrs. Sajida? Okay. I give you 5 minutes to present your paper here. Let's start now, Mrs. Sajida.
Thank you so much. Yes, I'm here. I really can't unmute myself, so thank you. Good evening, everyone, respected colleagues and chairs. My name is Sajida Humaira from Universitas Terbuka, and can you guys hear me? Is my voice clear?
Okay.
Okay.
It's clear.
So I will be, yes, thank you. Under the subtopic of law and politics in crisis, I will be discussing COVID and viewing COVID as a crisis, and see how it will be better governed through international law by integrating the Sendai framework for disaster risk reduction into the WHO pandemic agreement or WHO pandemic treaty. Can I share my screen here? Should I use my presentation or? Okay, I can share it now.
Yeah.
Okay, so as the title, I will be looking at pandemics as a global crisis and seeing it how it will be better governed through international law by integrating the Sendai framework for disaster risk reduction into the current pandemic agreement. So we can see that COVID-19 clearly demonstrated how pandemics are not only or merely a health crisis or health emergency, but rather a global crisis that disrupt economics, governance systems, and even international cooperations. Legally and politically, the pandemic has exposed fragmentation, unequal capacities between states, and also weak coordination mechanism. Despite this characteristic, pandemics are still largely regulated through the health lenses. However, we see from the Sendai framework of disaster risk reduction, it offers a broader way to understand the crisis as a product of risk, vulnerability, and also capacity rather than hazards alone. So we can see how, if we take a look at the Sendai framework, it has a multi-hazard approach that considers various risks, ensuring preparedness and response strategies address diverse threats. It integrates health and seeing it as a part of a whole crisis issues rather than individual problems. So the current pandemic agreement, which recently this year has been finalized by the WHO, has different principles that differ from international health regulations that specifically address the pandemic's issues. So within the pandemic agreement, we can see that the pandemic agreement primary objective is to enhance prevention, which in the previous IHR or international health regulations does not exactly cover a whole prevention aspect of the pandemic issues. Other than that, it also focus on preparedness by strengthening health systems and response mechanism. It also has a core principle of equity, which is many critics have said that the international health regulations is not providing equal treatment between countries when it comes to the pandemic preparedness. So within the pandemic agreement, currently it has more of the core principle of equity because it is essential of ensuring all the nations have equal access to resources, including vaccines and support. Thereby, it will promote fair and just response for health crisis. It also includes the core principle of One Health. The One Health approach recognizes the interconnectedness of human, animal, and environmental health. It emphasizes collaborative efforts between sectors to address pandemics. So between the two framework of pandemic agreement and also this Sendai framework, we can see some level of different convergence and divergence. From the convergence, we can see that both of this framework has risk prevention and also human rights value. For the risk preventions, both the Sendai framework and the pandemic agreement has emphasized risk prevention as a fundamental strategy, advocating for provocative measures to mitigate impacts before disasters occur. Also, both of this I would say framework, not a legal framework, but framework, integrate human rights approach in their framework. But we can see some level of divergence between the Sendai framework and pandemic agreement. The Sendai framework is a non-binding agreement, which means that it's not a legal instrument internationally, but it focuses on comprehensive disaster risk reduction through voluntary commitments. So compare that to the pandemic agreement, which is a binding treaty that can mandate states and or nations to ensure coordinated response. We can see how from the Sendai framework, it weaknesses the fact that it's not binding, while the pandemic agreement has that aspect. So if we combine the value that the Sendai framework has into the pandemic agreement, it will definitely strengthen the whole pandemic preventions issues. So what can we learn from the Sendai framework to include into the pandemic treaty? The first one is the stakeholder coordination. If we take a look at the pandemic treaty, there are not many many aspects of coordination in the treaty itself. But if we take a look at the Sendai framework, we can see that how the Sendai framework has a more multi-stakeholder coordination aspect to it. So if we combine that, if we learn from the Sendai framework and put it into the pandemic treaty, hopefully it will promote an inclusive and better collaboration when it comes to pandemic preparations. The second one is it's vulnerability-centered approaches. So when it comes to pandemic treaty, we don't see a lot of aspects of vulnerable community discussed in the pandemic treaty. So by making sure that this kind of value integrated into the pandemic treaty, it will definitely better the regulations of pandemics. The third one is capacity-based cooperation. So when it comes to pandemic agreement, it's still very much focused on health aspects to it. It hasn't been differ that much compared to the international health regulation. So by taking a look at Sendai framework, which has a more comprehensive and multi-stakeholder approach, hopefully by making sure each cooperation based on capacity will definitely be improving the pandemic preparedness better. The how do I'm sorry. Okay. Why did it not work? Okay, so the last one is how do I recommend, how do we integrate this value into the pandemic agreement? The first one is by embedding Sendai principles into the pandemic treaty. By integrating the principles of the Sendai framework to the pandemic agreement, it will definitely provide a comprehensive guide for disaster risk reduction and enhance global pandemic preparedness, and not seeing it as just individual issues. The second one is by strengthening local roles. Within the pandemic agreements, there are not many aspects of local roles discussed in the agreement, while in the Sendai framework, it focused a lot on how the local governments can take roles in managing disaster. So by including the local roles in the pandemic agreement, it will definitely empower local communities and enhance their roles to ensure the pandemic are context specific in each countries. The last one is to adopt risk-informed approaches. So in a multi-hazard and risk-informed approach will enable countries to anticipate and mitigate crises more effectively. It will foster cooperation and resilience across sectors and communities in the face of future pandemics. Okay, so that's all. Thank you so much for your attention. I will be giving the stage back to the moderator.
Okay, thank you, Mrs. Sajida Humaira. Okay, now the next speaker is Yudhistira Rushidi. Is there here? Mr. Yudhistira? Or Miss Sarlika Afrita?
Yes.
Yeah. You will be present?
Yes.
Yeah, okay. I give you 5 minutes. Time is yours.
Okay, thank you. I'm want to screen. Is there my presentation in screen? Sorry.
Oh, beda nyokin darat. Bukan jadi di bawah jadi darat.
Mrs. Sarlika Afrita, ya?
Yeah. Is there my presentation in screen already?
Not yet, not yet.
Oh, not yet. Yeah.
Not yet. Mrs. Salika?
Apa saya?
Okay.
Sorry, apa lagi masuk Maya?
I can to share. Maybe I have a signal ya.
Oh yeah, maybe. Maybe
For
just you just oral presentation never mind. Without without people,
Okay.
never mind.
Okay, thank you. First of all, I say thank you for moderator to give me chance me to present my presentation. The title of legal intellectual property rights, legal politics. In Indonesia, in order to optimize commercialization efforts and their economic benefits for Indonesia. Okay, for the introduction, I would like to say that during the colonial period, the intellectual property right in Indonesia was to I am protecting for the colonials, not the rather for indigenous people. So just for intellectual property rights, want to protecting the economic and trade interaction to colonialists. So in introduction, there is a for background and in this theme, one intellectual property rights have since colonial times and then harmonized with agreement treaties and still protectors oriented and the last high economic potential. We know that in our life, intellectual property like is a most important aspect. We can see until now so many web or the constitution who regulate about intellectual property rights. And then for the research problem in our presentation today, there is three themes or three topics. One, how to law commercialization of intellectual property rights, and how weak law enforcement, and three, law literacy micro, small, and medium enterprise. And then how about the research methods in our judicial research? We use the normative legal research in this research method with focus on positive legal, constitution norm, and legal doctrine about the who regulate the intellectual property of rights. Lalu, and then we just also to use the library research and qualitative analysis to answer many three problems in our topics means. And then there is to legal policy safe in this discussion. One of we want to discuss about how to protection paradigms. Two, how about to toward economics utilization, and how intellectual property rights as an economic asset. And then we also to discussion about how the government policies about intellectual property rights in Indonesia especially, and we have to compare in another country, not also in Indonesia. So many country who used to regulate the intellectual property rights. How about the challenge in this discussion or presentation? Uh, we just to see how about the commercialization intellectual property rights to progress in economics and trade for our country, especially Indonesia. Lalu, how about the domestic patterns and how to mengatasi weakness enforcement law in Indonesia? Okay, I think that's all for my presentation. I say sorry if I can't to see my slide in the presentation because I still have to trouble. Okay, I give the moderator. Thank you.
Okay, thank you for Mrs. Serlika Aprita. And we sorry to you. We can share your paper. And then we continue. The next speaker is there here, Mr. or Mrs. Walia.
Wafia.
Wafia, yeah, Mrs. Wafia.
Yes.
I give you 5 minutes to discuss your paper here.
Okay. Yes.
Good.
Is it visible now?
Yeah, possible.
Yes. Okay. Thank you, moderator. And Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, distinguished participants and my colleagues. My name is Hafiza Zia. I am from the Faculty of Law, Universitas Bengkulu, and together with my first author, Ibu Wafia, I will present our study entitled Regulatory Harmonization for FinTech and Digital Banking, Balancing Innovation and Consumer Protection. And in this presentation, I will explain how legal regulation can respond to rapid digital innovation in financial service while still protecting consumer and ensuring financial system stability, particularly in developing countries such as Indonesia. In this slide, I would like to explain the background of our study. Digital technology has significantly transformed financial service. Fintech and digital banking have changed how people access and use financial service, making them more efficient, convenient, and inclusive. And however, this development also challenged existing regulatory framework, which were originally designed for traditional financial institutions. And in this situation, show why the legal framework must adapt to digital transformation. And in this part, I will briefly summarize the main ideas from existing literature. And the literatures show that digital transformation in finance requires a regulatory approach that is no longer rigid. Many scholars point out the tension between promoting innovation and fulfilling the state responsibility to protect consumers and maintain financial stability. And therefore, the literature strongly support the need for integrated and adaptive regulation. And in this slide, I will explain the main regulatory theories relevant to digital finance. Public interest theory emphasizes that regulation aims to protect consumer and address market failures. Responsive and smart regulation focus on flexibility and adaptability. In practice, this is reflected in tools such as regulatory sandboxes and risk-based supervision. And these theories provide the conceptual foundation for balancing innovation and control. This slide focuses specifically on consumer protection issues. Consumer
in digital finance ecosystem face risks such as fraud, misuse of personal data, and algorithmic bias. Also, digital banking relies on advanced technology. It must still comply with prudential principle to ensure financial stability. The convergence of fintech and digital banking create supervisory challenges when non-bank fintech entities provide bank-like service but are not regulated in the same way. This gap directly affect the level of consumer protection. Oh, sorry. Data is a core asset in fintech and digital banking. Frameworks such as the GDPR in the European Union are often used as a global reference because they emphasize consent, transparency, and the rights of data subjects. And in ASEAN countries, include Indonesia, data governance standards are not yet fully harmonized. This makes data protection to key challenge in cross-border digital finance service. And I will briefly explain our research methodology. In this study, use normative legal research to analyze legal norm, regulation, and policies. We apply statutory and conceptual approaches, as well as comparative law approach by examining Indonesia, Singapore, and the European Union. And this methodology allows us to identify best practice and regulatory gaps. And we compare regulatory approaches across jurisdiction. In Indonesia, regulation have developed through POJK, PBI, and regulatory sandboxes managed by BI and OJK. Although fragmentation of authority remains a challenge. And in Singapore, applies an integrated regulatory model under MAS, while the European Union adopt regional harmonization through PSD2, GDPR, DORA, and MiCA. These differences show varying level of regulatory integration and maturity. And in this slide, I will summarize the key challenges and effective mechanism. Major challenges include fragmented regulatory authority, gaps between innovation and legal certainty, and data protection and cybersecurity risks. Effective mechanisms include integrated regulatory sandboxes, proportionate regulation, IP-based open banking, and digital operational resilience standard. This mechanism demonstrate particular ways to balance innovation with consumer protection. To conclude, harmonizing fintech and digital banking regulation is a strategic necessity in digital era. Indonesia has a strong regulatory foundation, but challenges remain in institutional coordination and integration. Experience from Singapore and the European Union show the adaptive, coordinate, and risk-based regulation can maintain a balance between innovation and consumer protection. Therefore, strengthening regulatory harmonization is essential to build a safe, inclusive, and trustworthy digital financial ecosystem. Maybe that's all I would like to share in my PPT. Maybe I would like to happy to take any question, and I will give back to moderator.
Okay, thank you for Mrs. Alfiza.
Yes.
Yeah, in this session, there are not question session, so we just only oral and video presentation. Okay, we
Okay,
hope.
thank you.
Yeah, thank you. Okay, next, I call Mr. Abdul Hamid Usman. Are you here? Still here? Or Helwan Kasra? Are you still here? Or Miss Lirin Agustin? Okay. For the next presentation, I call Abdul Hamid Usman. Are you here? Mr. Helwan Kasra? Okay.
Sorry, sir. Ririn Agustin in here.
Ririn Agustin maybe, yeah?
Yeah, maybe.
I'm
Yeah.
here, sir. Sorry for my signals.
Okay. You have a problem with signal.
Yes.
Yeah, but okay. Good. Maybe I give you 5 minutes to present your paper.
Thank you, sir. Allow me to read.
Okay, Miss Ririn Agustin, time's yours.
Right, sir.
Still any problem?
I don't know my
Maybe
cannot show up.
you still have problem with your connection.
Sorry, sir. I think my PowerPoint. Yes. My PowerPoint cannot show up. Can I start it with the PowerPoint? Hello?
Okay, Miss Ririn. Maybe I give you 4 minutes to repair your connection. Is it good? Is it good now?
Good, sir, but still my PowerPoint can show up. Can I start it with the PowerPoint? But
Yeah, is it over mine? If you presentation without paper, it's never mind.
Okay, thank you so much. So good evening, everyone. So I want to present a study titled Construction Dispute Council as an Alternative Dispute Board, explaining why the dispute board provided faster, more efficient, and project-friendly dispute resolutions. Focusing on how this dispute board serve as an alternative approach to certain construction disputes. The background is explained that disputes frequently occur in construction projects due to issues such as contract misinterpretations, delays, and technical problems. These disputes can interrupt project progress and increase costs. Therefore, understanding effective dispute resolution mechanism is essential. Research problems. This outlines the main issue explored in the study. It seeks to identify the factors that influence the choice of dispute resolution methods and determine whether arbitration or the dispute board offers better outcomes for contraction actor. We use research method that clarifies That study adopts a normal legal approach. It relies on analyzing laws, regulations, and court decisions related to construction disputes. This method provides a strong theoretical and practical foundation for evaluating the two mechanisms. Constructions dispute definitions. Well, the slide describes what constitutes a construction dispute. It also elaborates on common causes of disputes, helping the audience understand how disagreement emerge and emerge and escalate into significant conflicts during construction activities. Arbitrations explained out-of-court dispute resolution method that results in a final and binding decisions. Although it offers legal certainty, arbitration can be time-consuming and expensive when dispute have already escalated. Dispute board. This slide describes the dispute board as an independent panel that becomes involved from the beginning of a project. Its primary role is to prevent dispute from escalating, allow for faster and more cost-effective resolutions compared to arbitrations. Research findings showing that most respondents prefer the dispute board. This prevents reflected the need for continuous project progress, legal certainty, and good working relationship among all parties involved. Conclusions highlights that dispute boards are more effective in resolving construction disputes. They provide early detection of potential conflicts and help maintain efficiency in both time and cost management. Recommendations suggest that Indonesian construction practitioners should become more familiar with Federation International Gas Engineers Council's standards and incorporate dispute board clauses into the future contracts to better manage potential disputes. I think that's all of my PowerPoint presentations. Thank you to Mr. Soleh. I will give it to you back. Thank you so much.
Thank you, Ms. Ririn Agustina from Universitas Muhammadiyah Palembang. Okay, all participants and all speaker, we move to video presentation from the speaker here. There are maybe 2 videos will be played here, and the first presentation by video from Miss Helda. The operator can play. Mrs. Helda video's presentation. Mr. Ade, can help me? Mr. Ade? Or Mr. Andri, are you here? To share the video presentation from Helda. If there is problem, maybe I call next presenter, maybe Mr. Agustinus Pambang. Are you here? Or Adi Sulistyo? Albertus Sentot Sudarwanto? Are you here? The next presenter, maybe. I hope you stay here. Maria Margareta Alacho Kahlasi. Are you still here? Maria? Is there here, Maria? Or Pierre Mario Bait? Is there here? Mr. Pierre? Okay. Okay. Maybe there is presenter here. There is speaker will be share or will be explain about the paper. Okay. Maybe there is a problem with our presentation, oral presentation, or I would like to say thank you for all the speaker here, and you have give the insight presentation and share such valuable knowledge with us today. Those are the oral presentation of the second international conference on law, policy, politic and policy at our ICONLAPP 2025. Let's give applause for our speaker. Okay, and we would also like to thank all participants for your active participant here. I say thank you very much for all the presenters here, for the speaker here, and we hope this international seminar has been beneficial and inspiring for anyone. This is the last session for us, and then we close this session by say Alhamdulillahirabbil alamin. I hope okay. Mrs. Nahla Jamili.
Yes, I'm right here.
Okay. It's not never mind. You will present your paper?
Yeah. I'm
Okay.
about to.
Okay,
Give me
maybe.
time. Let me share my screen first.
Okay. Thank you. Maybe I give you 5 minutes.
Okay.
Can you share your paper?
Wait, let me try.
Okay.
Hold on. Is it working? Is it showing on?
Not yet.
Yeah.
Not yet.
Not yet?
Yeah.
But then my laptop is here. I don't know why, what happened with my laptop. But is it showing?
If you cannot share your paper, maybe you can presentation by oral. Never mind.
Oh, okay.
Every operator, maybe our operator will help you from here.
Okay. Thank you for that. Assalamualaikum warahmatullahi wabarakatuh. Well, good afternoon, distinguished speakers, respected panelists, and fellow participants. Thank you for the opportunity to be present in the international seminar. Well, today I would like to present a paper entitled Implementation of the Anti-Strategic Lawsuit Against Public Participations, or aka Anti-SLAPP, Mechanism in Environmental Justice Law in a 20 Sustainable Development Goals. This paper is mechanism instrument for environmental matters where activists, communities, and civil society organisms often face legal intimidation. In the context of the environmental justice and the environmental law, anti-SLAPP play a strategic role in the safeguarding democratic space and ensuring access to the justice. However, despite their relevance, the implementations of anti-SLAPP in Indonesia continues to face legal and institutional challenges, including limited understanding among law enforcement authorities, weak regulatory frameworks, and the absence of the uniform standard in the handling cases involving environmental defenders. Based on the background, and the study aims to analyze the implementation of the anti-SLAPP mechanism within the framework of the environmental justice and the environmental law, as well as in contribution to achieving the 2030 Sustainable Development Goals, particularly SDG 16 and SDG 13. And I would like to tell you also about my research problem and also the objective. The first one is like weak implementation of anti-SLAPP, and the second one is about criminalization of environmental defenders. And the last one is about the procedural, well, the formalistic public participations. And about the objective, the first one is about analyze and the SLAPP or the SLAPP implementation in Indonesia. And the second one is examine relevance to environmental justice and SDGs 2030. And we're going to move on about the methodology. This research adopts a normative legal research approach by examining statutory regulations, legal principles, and relevant legal doctrines related to anti-SLAPP and environmental law. This approach is used to evaluate the adequacy of the excessive legal framework and its role promoting access to justice, public participations, and sustainable environmental governance. And also, I would like to tell you about the implementation challenge. The first one is about limited law enforcement capacity. Second one is economic political dominance. The third one is misuse of the defamation provisions. And the last one is about weak protection for defenders. And about the disharmony regulations. Oh, sorry, wait. And also, I would like to tell you about the environmental justice issues. The first one is about power imbalance, about the corporations vs communities. The second one is AMDAL, often administrative, not substantive. And the third one is indigenous communities face criminalization rates. And the last one is about ecological justice, but not fully realized. And I also I would like to tell you about the public participation and dispute resolutions. The first one is participations. Well, there is monitoring, reporting, policy criticisms, and there's obstacles, intimidations, low legal literacy, dispute resolution, and then litigation, and there's ADR, meditation, ombudsman, Komnas HAM, and the last one is about requires anti-slave protection. Um, well, sorry. And I would like to tell you about the conclusion of my research. Well, the conclusion is like anti-SLAPP is essential for environmental justice, and the current implementation in agreement is very big. And the last one is like the policy reform and institutional strengthening. Well, I think that's all. Thank you for having me, and I would like to back to the moderator. Thank you.
Thank you for Miss Nahla Jamili Rahman Muhtardi. Okay, maybe if there is a speaker here, I will give one more speaker as the last presentation here. Any speaker here will discuss about paper. If there is not a speaker again, maybe we can conclude our oral presentation here. Is there any speaker here? Okay, I think it is enough for our oral presentation for this session. And for all speaker, we will share book of abstract soon before proceeding. And then the certificate from this session, from this second international conference, Law, Politic, and Policy, will share you for your email or your Google Drive. I say thank you for all the speaker and participant here. And this is the last session for our second international conference on Law, Politic, and Policy 2025 on collaboration between Faculty of Law and Faculty of Social and Political Science, Universitas Muhammadiyah Bengkulu 2025. The last, and once again, I say thank you for all the speaker and participants here. And then we close our session by Alhamdulillahirabbil alamin.
Recording stopped.
Okay. Thank you for your attention, and I close my say. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.